Requesting for listing of a rate petition on an urgent basis tomorrow. Might have been
Motion.
motion.
Yes, motion.
We've already filed it.
Yes, motion is.
May I please, Your Lordship? Item number 25, we have filed the additional affidavit and the respondents have
Bring
filed
it.
deeply applied.
Lordship, I beg to mention item 44, it's a contempt case, Lordship. The same has been, the order of this honorable court has been complied with, Lordship.
Here for the petitioner.
Yes, Lord.
Three SD learned counsel for the petitioner has submitted that the order in question dated so and so, past in so and so, has been complied with in the meantime. Full stop. Also heard, Mr. Nath, is he there in the court? Is Mr. Nath there in the court?
Yes, yes.
Also heard. Three, we record your name. 3 G. Anthony, learned counsel, appearing on instruction of 3 D. Nath for the response number 1. Para. In view of the aforesaid development, this court is of the opinion that there is no further requirement of continuing in this proceeding. Full stop, para. Accordingly, the same stands closed. No.
Much obliged.
May please, Your Lordship.
Date kata did you? WBC number did you? Yes.
Lordship, with the consent of the other side, I beg to mention item number 12, Lordship. I am for the respondents, Lordship.
Yes.
If 1 week's time may be given, Lordship, we will be filing our affidavit in opposition, Lordship.
12,
12, Lordship.
21 matters.
Yes, Lordship.
Why?
Lordship,
Why
we
should
need
you
some
give?
time, Lordship. We have already prepared the affidavit, Lordship.
Why should you give it time of 21 matter? You have not filed all the 5 years. Why should you give it time? Not adjourning matter.
Some time may be given, Lordship.
Sorry. Let the matter which we'll see then.
May I please? Latest 2 matter, admission matter may come for listing on Monday, my lord. We have already
Motion.
No, admission.
Admission.
Government, government has also filed my lord affidavit. We have
Sorry,
also filed,
sorry.
my lord.
Admission, if out of turn listing, it has to be urgent. Motion, yes, no problem.
Make-
Admissions, it has to be urgent, not by out of turn. We approach the registry. Yes, next.
May I please, Lordship? I beg to mention item number 22, Lordship.
20.
22.
22.
Yes,
Yes,
Lordship.
what is it?
Yesterday I have filed affidavit, Lordship. Lordship. Finally, released the matter after 1 week, Lordship.
You have filed the affidavit in reply.
Yes, yesterday, Lordship.
Yes,
Lordship,
your Gigi Gogoi.
Yes, Lordship.
Yes, what is it?
Lordship, we are seeking an accommodation, Your Honor. If the matter is adjourned, Your Honor, may like to take it up on 9th of February.
9th, okay. 3 G. Gogoi, learned counsel for the petitioners, has informed that the reply affidavit has been filed yesterday.
Yes, Lordship.
Full stop. Is it on record? 1000? Has it come to the record?
No, Lordship.
Have you checked the file,
Yes.
which is not tagged with the records para? Registry to verify and tag the affidavit in reply on record. Tag the with the code file. Full stop para. List on 9th.
9th of
9th.
February.
Sri N.R. Surana, learned counsel for response number 4. No, first right CGC. Any CGC? Any CGC?
I have obtained instruction, Lordship.
No, anyone in the court?
With permission, Lordship, I have already
We know that. We want to record the name. Is any CGC there?
Mrs. Egan was there.
Miss Egan, learned CGC and Sri N.R. Surana, learned counsel for the response number 4 are present. Yes.
much.
May I please, I pray for listing a writ petition, my lordship.
Motion.
No admission.
Admin urgency.
I think that there is a boundary dispute between the petitioner and respondent. The matter is fixed on the report to the.
It is not an urgency. Sorry.
That no.
Sorry. That is not the purpose of a mentioned memo. Yes, Mr. Chakraborty.
For listing, my lord, for orders, my lord, it's a matter of 2019 against an award. Last year it was listed and there was an order passed by your lordship.
19 matter. Okay. 19 matter.
For orders on 30th of this month.
Yes.
May I please for receipt, my lord? Item number 13, my lord, with a consent, my lord.
30.
13, my lord.
13, 13.
I need
Yes.
some accommodation, my lord.
22 matter. Why are you seeking time?
Let it be after.
Why are you
Day
seeking time for 22 matter? We are in 2026.
My lord, day after tomorrow, maybe. Let it be, my lord.
Okay, day after tomorrow.
All right.
On the prayer made by Sri N.K. Mari, learned counsel for the petitioner, matter is adjourned to be listed on Friday is a holiday, not day after tomorrow. Why are you seeking accommodation, adjournment?
Today we will be filing, my lord, only.
What, filing what?
A reply.
reply.
Yes, madam.
Okay, then. Sri N.K. Murray, learned counsel for the petitioner, has submitted that reply affidavit would be filed during the course of the day. Full stop. Para, in view of the above, matter is adjourned to be listed on 27th, 28th.
Replies, my lord.
May I please, Your Lordship? Your Lordship, I beg to mention one.
Inform the other side, Mr. Murray. Agriculture. Ms. R. Bora, learned standing counsel agriculture represent. Yes.
May I please, Your Lordship? Your Lordship, I beg to mention one writ petition for listing under admission column, Your Lordship, after vacation.
Urgency.
Urgency, Your Lordship, is pertaining to tender matter, Your Lordship, and the tenure of the tender is about to complete, Your Lordship. On 29th, if possible, Your Lordship.
Tender is about to complete. How is it urgent? It's already been working underway, not a matter of mention memo. Sorry.
Lordship, actually, what has happened in this case, Lordship? There is one interim order, Lordship. Tender was awarded, Lordship. That has been stayed, Lordship. Stay order is
You
out.
file an application for modification,
Lordship, in our favor, Lordship, stay has been granted, Lordship.
then
On 28th, Lordship. Otherwise, Lordship, on
sorry, that is not the purpose of mention memo. Mention memo is only for extreme urgent matters. Motion, yes, motion, there is no problem at all. Yes, next. Madam,
Is your lordship? Lordship, on behalf of P. Bharadwaj, I beg to mention item number 21.
21.
Yes,
Yes,
with
what is
consent of other side.
Hmm.
Lordship, I pray for 2 weeks of time for filing the affidavit in reply.
Okay.
On behalf of respondent number 6.
Okay. But P. Bharadwaj is for the petitioner.
Yes, Lordship.
You are for respondent number 6.
No, I'm for
We will file a rejoinder affidavit. Okay. What is your name, madam?
P. Parasol.
Ms. B. Parashar, learned counsel for the petitioner. Prays for and is granted 2 weeks time to file rejoinder affidavit. List
Like the-
on, we give a date, madam. Today is 21st, 2 weeks, 1, 2. List on 9th of February. 9/2. Yes,
May I please, your lordship? I beg to mention item number 50.
15.
50.
50. Yes, what is it?
My senior is out of station, your lordship. Can you adjourn the matter for today?
50 is connected with other matters. Which item? 50. 50 is connected with many matters. Who is your senior?
Okay, David.
There is no 15. Madam, you have to check the number properly.
Also, so sorry, your lordship. It's 58.
58. These are orders. We have to check the records. It may be for steps. Not going to adjourn. We'll accommodate you. Don't worry. But we'll check the records. Be here when the matter is called upon. Yes.
Well, here the appellate authority has passed the order. Appeal has been disposed of. His grievance is that appeal has not been considered. The order has been passed and they have received the order.
We close this. If you want, you can challenge this
Yes.
appellate order. What is your name, madam?
K. Bharali.
K. Bharali. Heard Ms. K. Bharali, learned counsel for the petitioner. Also heard Sri D. Nath, learned senior advocate, Assam. Para? The challenge was pertaining to a notice dated 27/10/2025 issued by the Joint Secretary to the Government of Assam Home and Political Department, whereby the petitioner was directed to appear in person before the appellate authority along with the arms and arms license. Full stop. This court, wide order dated 19/12/2025, had directed, and 19 after hearing, the Learned State Council had directed to obtain necessary instructions as the application was still said to be under process. Para? Srinath, the Learned State Council, has submitted that in the meantime, a speaking order has been passed on 22/12/2025 by the appellate authority. Full stop. It appears that the grievance of the petitioner, which was raised in this petition, has been substantially redressed. Full stop. The petition accordingly stands closed. Full stop. Liberty is, however, granted to the petitioner to challenge the speaking order mentioned above, if so advised in accordance with law. The speaking order dated so and so is made part of the record.
The direction of authority parties is 14 will also, para 5.
Okay. Heard 3 L. Mohan, learned counsel for the petitioner, who by means of this application has complained of willful and deliberate disobedience of the order dated 13/9/2024 passed in WPC 3574 of 2024. Full stop. The learned counsel has also drawn the attention of this court to the representations and also an order dated 7/11/2025 passed in contempt case 558 of 2025, whereby certain liberties were granted to the petitioner. Full stop. Para. Let notice be issued, returnable on on 23rd of February 2026. Let steps be taken for service of notice upon the respondents by speed step within 2 working days.
3 and 4. 3 and 4. 3 and 4.
3 and 4, okay, same. The but the orders will be different. Subsequent orders, contempt.
Subsequent order, contempt is, order within 8/24 passed in WPC.
Irresolvable at a particular contempt. Okay. And the respondents are the same. Okay. You take steps by tomorrow.
Item 5.
Thank you so much.
Yes.
Lordship, I came before your lordship to file an additional application, but that was not required, lordship. Now, lordship, here in this case, lordship, the petition was agreed by the selection of the respondent number 5, lordship, for the petrol pump. Lordship, your lordship may kindly please page 18, lordship.
R5 has been selected
Lordship, R5 has been selected.
for petrol pump, retail petrol pump.
LOA has been issued, madam. So, lordship, here, lordship, as per NIT, lordship,
What are your grounds?
lordship, my ground is that, lordship, I also participated amongst group 1 loan. But the respondent number 5, which the land which was offered by the respondent number 5, lordship, for setting up the petrol pump, lordship, that was not as per specifications given in their NIT loan.
What is the fault?
Lordship, they selected, lordship, in spite of the petitioner being fully eligible, lordship.
No, what is the fault in the land?
Lordship, that was not as per specification, the land and wide, lordship. That was not as per specification.
What is the that is what we are asking. What is the specification? What is the violation?
As per lordship, NIT lordship, that should be 35 meter by 35 meter.
Okay.
But as per information lordship, revealed from the lordship, revenue authority lordship, that was only lordship, the frontage is 80 feet and the length is 72 feet, which is around 24 meter width. Much lesser than the.
Where is your environment regarding this?
Page 11, paragraph 11, lordship.
Para 11, page.
Page 9.
Different land.
There are two darks, lordship.
Hmm?
Looking differently.
Paragraph 11,
Paragraph 11,
page 9.
page 9 of my.
Yes, please read.
That the petitioner begs to state that the number 5 offered land comprising of 2 cattle in DAG number 458 and 1 bigger 10 letters in DAG number 459. However, a trace map dated 33/2024 issued by the circle officer and information dated so and so obtained by RTI revealed that the land of respondent number 5 adjoining the road, DAG number 458, has a frontage of only 80 feet, which means 24.41 meter. And a breadth of only 72 feet, means 21.9.
Yes, what do you say, Mr.
But
Bhattakur?
the land is defined, madam.
Hmm?
The tag number is also defined, madam.
Different.
Yes, madam. Tala.
Why did you seek information about another land? RTA is for another land.
Yes.
My lord,
It is already commission also, madam. It's
No, that
applied.
is not the,
Yes.
but if the land is different, Mr. Bob here.
my lord, because lordship in the last round of litigation lordship, they stated that the land was not yet verified. Lordship. Now they are stating that land is different, lordship. But in that area.
At best, we can issue notice at this stage, nothing. But you are not going to gain anything.
They may came up.
You file an affidavit.
Yes. Yes.
If you file an affidavit, then without even issuing notice to the respondent number 5, we can close this.
Yes, obviously.
But let us see. Hertz Tree NH Borbia, Learned Counsel for the petitioner. First up, the grievance of the petitioner is with regard to the allotment of a retail petrol pump outlet to the respondent number 5. Full stop. The principal ground of challenge is that the said respondent number 5 is not eligible with regard to the requirement and specification of the land in question. Full stop. In this connection, comma, the learned counsel has drawn the attention of this court to the averments made in paragraph 11 of the writ petition, along with the connected documents which relates to information obtained under the RTI Act. Full stop. Para 3. As Bhattakur, learned counsel, appearing for the BPCL respondent, has however submitted that there is a fundamental flaw in making the challenge, in as much as the land in question of the respondent number 5 is different from the land which has been mentioned in paragraph 11. Para. Be that as it may, comma, let notice be issued. Returnable on 16th of February 2020, not 16, 20th of February 2026. Yeah, for whom?
No warrant to one.
3. As Bhattakur, learned standing counsel. BPCL accepts notice on behalf of respondent 1 and 2. And Miss Udas, learned state counsel for 3, 4, 3 and 4. Extra copies. Steps for service of number 5, register, not register, speed post utility steps by tomorrow. The learned standing counsel has also submitted that the letter of appointment has already been issued in favor of the respondent number 5. Yes. For?
Other tweets have to file additional evidence.
The matter pertains to our direction for release of contractual dues, para. When this matter had come up for consideration on 7/1/2026, this court had noticed that there was no document of any acknowledgement of liability, full stop. The learned counsel was accordingly granted time to file additional affidavit, para. Sri Mohan, the learned counsel has renewed his prayer for more time to file such document. Para? In view of the above, matter is adjourned to be listed on 13th of February. Item 7. Mr. Ghosh?
No, I've got the instructions.
Yes.
Here, Lordship will have a look at page 99 for a moment.
The DB matter is still pending.
Lordship will have a look at page 99 before
90
going.
now, the writ
Page
petition.
99 of the writ petition, please, before going to the my lord, instructions.
Yes, please.
The earlier tender was extended till my lord 17/11/2025.
17?
17/11/2025. He challenging the retender 18/11. But my lord, the earlier tender was extended till 17/11/25 during the pendency of the writ appeal. Now, Lordship will see page my lord 102. This is an IA referred by the writ petitioner in the writ appeal. Lordship will see my lord page 103.
103?
103.
Yes, please.
It says the learned counsel for the applicant submits that that this court by order dated so and so has permitted the applicant to participate in the retender for which the applicant requires a site visit certificate. Despite the applicant visiting the site, the respondent numbers 2 and 5 for reasons unknown to the applicant has not issued provided the applicant with a site visit certificate. The applicant's counsel submits that the last date of submission of the bid is 17/11/2025 and as such, the direction should be given to the respondent concerned for issuance of the site visit certificate. So and so appearing for the said respondent submits that the site visit certificate will be issued to the applicant so long as the applicant had visited the site in terms of the requirement for issuance of the site visit certificate. Then Lordship will see, my lord, when it was issued, it has been recorded in the next court's order, page 113 in the writ appeal. Page 113. Third para.
Yes.
Mr. So-and-so, counsel appearing for PWD, however, on the basis of the instruction received by him, submits that a site visit certificate has already been issued to the executive by the executive engineer so-and-so on 15/11/2025. The appellant has also been informed about the site visit certificate by the concerned division on the same day of issuance of the such certificate, and he has been requested to collect the same from the division. Last date was 17/11, that was the extended time. And my lord, this is a recorded that on 15/11 it has been issued and petitioner was informed. Now, Lordship will see my instruction, my lord, on 30/12 he has collected the site visit certificate. 30/12, that is what I've got the instruction.
30/12?
Yes. Now, my lord, since my lord, there is an order that the petitioner should be allowed to participate. And my lord, in the meantime, 17/11 has elapsed. So a decision was taken that we'll go for retender so that he can be facilitated to participate in the, because it's a ZAM portal, it got closed. So he cannot accept a, my lord, physical copy later on. For that, my lord, the retender has been issued. This time also till 9/3/1, my lord, like extended date, he did not participate. On 30/11/12, my lord, he has received the copy after more than 1 month.
As per the new schedule, what was the date?
3/11 was the 3/1/2026 was the last extended date. And on 30/12/2025, he collected the copy. On 15/11, it was issued, 2025.
And within 3/1/2026, he did not, he failed to.
Even, my lord, in the recent, my lord, even then, my lord, on 17/11,
What is
was
your
already over.
grievance, Mr. Ghosh?
He has missed the bus.
What is your grievance?
My grievance is, Lordship will see, they have said on 15.
Because on the first occasion, which you remember,
Yes.
you said that the DB was in session of the
Yes.
matter. In spite of that, you have not been given a chance.
When the first NIT was issued, my lord, let me, my lord, submit an forensical OMB. On 24/6/2025, NIT was issued, my lord. Lordship will
24?
24/6/2025.
Yes.
That is the first NIT at page 29. Then, my lord, we submit our bid. Our technical bid was qualified. We qualified in the technical bid. We also, my lord, qualified in the financial bid also, L1. Then they sought some clarification regarding non-disclosure of it. According to them, it is an ongoing project.
Oh,
existing
they
code.
sought clarification regarding?
Regarding, my lord, non-disclosure of a, my lord, substitution of ongoing work.
Okay.
We replied it, my lord. We
Hmm.
clarified our position, my lord. They did not, my lord, pass any order on that, did not consider it also, my lord. Then, my lord, suddenly my lord, cancel this that NIT, my lord, 24/6/2025, my lord. On 6/10/2025, that my lord will get us page 42.
Yes.
Then, my lord, 7/10/25, they should retender notice.
Retender.
Retender notice, my lord. Assailing that retender notice, she filed a first writ petition, my lord. That was 5969 of 2025, lord. And that was dismissed.
What is
my
the
lord.
repetition number?
Yes, 5969 of 2025.
Yes.
That was, my lord, disposed of along with other three disputation, my lord. We are concerned it out only, my lord. That order, my lordship will get at page 47 to 84. Then, my lord, will,
What had happened there?
that, my lord, my disputation was dismissed, lordship.
Okay.
Then, my lord, will, on 29/10/25, they issued the retender notice after dismissal of our
20?
disputation. 29/10/2025. That, my lord, will get at page 85.
Retender notice. Yes.
Then, my lord, 7/11/2025, when he assailed this, my lord, honorable single judge order before the division bench, that on 7/11/25, lordship will, division bench passes an order, my lord, allowing us to participate in the retender process without prejudice to our right involved in this, writ appeal, my lord, against in which we have challenged the, my lord, honorable single judge order. Lordship may kindly look into page 87 first, my lord. That will
Now,
clarify.
what is your present grievance?
My present.
With participation in the new retender?
That went to them, they, for a 5 BG certificate. They did not issue. us
No,
any-
those who have understood, those Mr.
Yes, yes,
Last
yes.
occasion we remember.
Yes, my.
Now, the site visit certificate was ready on 15/11/2025.
Lord, I'll just place 3 documents to my lord. My lord. will-
What is the present position, Mr. Gogoi?
Lordship,
My lord, there is a, my lord, status quo given by this honorable court so far as the first is concerned, latest tender is concerned.
Lordship may kindly look into this 3 letter. That is their letter, not my letter.
No, site visit is there on
On
30/12.
38/12,
You have collected. Oh, that date.
38/12, Lordship kindly see 38/12/2020.
Okay. Now, when was the last date? 3/1.
That is regarding to visit this, my lord, the retender.
Hmm.
This lordship will kindly see 103 order again, my lord, page 103.
Hmm.
What they have submitted before this honorable court.
Hmm.
Lordship may again look into page 103. That my lord.
No, Mr. Ghosh, all said and done.
Yeah,
See,
That is-
see,
this is retender
just
notice.
let's be patient.
yes.
He says, Mr. Gogoi says that on 15/11/2025, the information was given,
Yes.
but you have placed on record a certificate which is dated 30/12.
30/12.
But still you had the time to submit your tender bids on 3, because
My-
it's in 3/1/26. Why didn't you?
My lord, that is regarding the fresh tender, which they have issued
Yes,
after cancellation.
yes.
Lordship will kindly see when they issue the.
So what
first-
is your grievance now?
Yes.
What is your grievance?
My grievance is regarding the retender notice. The retender notice, court has given us an extension to file a submit.
Yes.
Issued us a site submission certificate so that we can submit our bid in a retender notice, not in the fresh tender notice. What my learned friend is saying about the fresh tender notice, my lord. Fresh tender notice was never a subject matter of this. We have challenged the first tender notice, which they, against which file a.
No, what is the distinction between a retender and a fresh tender?
Yes, it's.
My retender, my lord, they against.
The earlier work was cancelled.
Cancelled.
That is the subject matter of challenge before the DB.
DB.
DB says that in the retendering process,
I can participate.
you can participate without prejudice to your rights.
Right, in the involved with the.
Now,
What is
this,
right?
now you say that your site certificate was not there. Site
Ah.
certificate admittedly is there on 30/12/2025.
By this time, retender process was over.
It wasn't over, it was 3/1/26.
It is regarding the fresh tender notice, my.
When was the retender? Last day?
Retender was 18/11.
Yes, that is the crux of the matter, my lord. They have cancelled again that retender notice also, that my lord will find at page 17/12/2025.
Mr. Gogoi, why are you making it complicated?
Yes.
Let him participate. You have given the site certificate.
Yes, it has been given on my lord 30/12. Now, my lord, as per my lord, whatever document he has furnished, my
Yes.
instruction says that my lord, it is on 15/11, it was issued, he was informed.
No, no, see, this site visit certificate is 3012.
Yeah,
That, my lord, of course.
That you can see, you should be we should be aware of this.
even in a 17, my lord, when they made a submission before the honorable division. where
See, more
they did not
participation,
make
how does it
more
prejudice you?
That
You should be happy there is more participation.
Lordship. 3012. Because my lord, even in the, my lord, press tender also, because without changing any terms and conditions, it has been retendered. He is.
Now, when is the next
You
date
need not
of
to
the
worry.
new tender?
New one
311.
is 311.
3-1.
3-1, sorry. So
Over.
that is over. We'll have to again, we'll extend it, my lord. We'll have to extend it.
Extend it.
Otherwise- So
Extend
my
it.
lord, in that case, let it be a 2, I will place the instruction. It
Place
can
the
be post
instruction.
date.
See,
If at all it can be extended.
tentatively what we are going to pass.
Yeah, instead of
We'll-
interfering with the, my lord,
Yes,
retender.
yes, we are going
Because
to.
terms and conditions are same, my lord.
See, the liberty which was granted by the Honorable Division Bench, will maintain that.
That's
He'll be allowed to participate in the extended time
If at all it can
and
be.
without prejudice to his rights in the writ appeal.
Yes,
You take instruction, 2 o'clock.
at 2.
You can
My
give this back at 2 o'clock.
lord.
And this to Mr. Ghosh,
Lordship.
you can place it on record at 2 o'clock.
My lord, may I bring my additional affidavit also?
Not required. You are allowing your petition. You want participation. Why do you want delay? You want dismissal or what? Yes, Mr. Bora.
Limited pair, my lord. Problem is that my petitioner was, my lord, a settlement holder, my lord. He has, my lord, as per direction of the AFDC Director, Managing Director of Assam Fishery Development Corporation. He has in the year of, my lord, 23-24, my lord. He has deposited entire amount 72 lakhs something, my lord. But he has get the possession on 24/8/2023, and that excess amount may be adjusted with pilot next financial year when they did not do it. Matter so many affidavit representation was filed by the they did
Okay,
not.
we'll issue notice at this stage.
Yes.
Heard Sri N. Bora, learned counsel for the petitioner. Full stop. As per the facts projected, pursuant to an NIT dated 4/7/2023, issued by the AFDC, the petitioner was awarded the settlement of Haribhanga Mean Mahal in the district of Nagaon. Full stop. It is the case, the petitioner's case is that thereafter the bid value of rupees 72,05, 200 was deposited. Full stop. However, there was a delay.
2023-24.
However, there was a delay in giving settlement.
No, oh yes, delay, no, settlement was given on 24/8/2023.
Deposited would be in the financial year 2023-24.
Fine.
Full stop. The settlement was, however, handed over. The possession was, however, handed over when?
24/8/2023.
24/8/2023. So what is your grievance?
Grievance is when the entire 72,000 they have deposited, but remaining that amount minus 26 lakhs, they did not adjust his next financial year. My lord. Page my lord 47 is
The
represented.
grievance of the petitioner is with regard to non-adjustment of the remaining amount in the next financial year. Full stop, para. Let notice be issued, returnable. On we give a date. Who are the parties? Yes, Mr. Bora, where is AFDC a party? What kind of arraying of parties, Mr. Bora? You are a citizen council. You make the MD a party, AFDC is not a party.
Yes. The managing director of Fishery Development.
You should make the AFDC a party, make it represented by the MD. Why this kind of clause?
Development Corporation, my lord.
Managing director is not the entity. Entity is the AFDC, the corporation,
The settlement.
settlement holder.
Managing director assigns.
He acts on behalf of the corporation. Corporation has to meet. We are not here to explain everything to you. Should know. State of Assam, Fisheries Department, madam.
Yes, counsel.
He'll take.
P. Sharma is appearing.
He'll take. Okay, what is your name?
R. Chetri on behalf of P. Sharma also.
And the others? 2 and 3?
All respondents.
Okay. 3 R. Chetri, learned counsel appearing on instruction of 3 P. Sharma, standing counsel, Fisheries Department / AFDC, accepts notice on behalf of the respondents. Extra copies. List. Let the returnable date be on. No, notice. Returnable on. 20. On 23rd.
Pendency don't party represent.
Para. Sri Bora, the learned counsel praised for an interim order. Para. Considering the above, it is observed that pendency of this petition shall not be a bar for consideration of the representations.
Yes.
Dated 9/12.
Dated 9/12/2025. Okay, next.
Actually, partly minor, during the pendency minor, filing this petition minor, he's challenging the minor termination of the settlement order minor. And that was modified by the, in the meantime, during the filing.
Would you like to withdraw this?
Withdraw this, modified.
Okay.
Withdrawn.
Heard Sri and Bora, learned counsel.
One pair is there, minor. There is a minor, order was there, minor, is a, that order was not complied with, minor.
Which
That
order?
there is order, minor, please may kindly see, minor. And
No, if you want to withdraw, we withdraw. We cannot make any observation. Other, if you want to,
two pair is there.
then if you want to sustain this, you are not. Are you withdrawing or what?
Oh, minor. First pair, minor, because of that was minor modified. so
We
pair,
cannot
minor,
segregate now. One pair withdrawn, the other remains.
Because of that.
Either repetition goes or repetition stays.
Minor, in spite of honorable case order, they did not.
And we issue notice.
Yes, counsel.
We issue notice then.
Yes.
If you are in consideration of your second prayer, we have to issue notice, give them a chance.
The pair, minor, only because of that, the honorable court directed to,
Which prayer has not been considered as yet?
minor pair of 5 minor.
No, in the relief, page 31,
33 minor.
page 33.
Pair of 4 minor.
That is a different cause of action.
Minor,
Comply with the
main
direction.
issue-
If
main
it is,
issue is minor,
if it is not complied with, you file a contempt.
Yes.
We give you the liberty. Okay. Heard Sri N. Bora, learned counsel for the petitioner whose principal grievance was against and order dated 22
26, 2025.
page,
It's minor, 98 man.
order dated 26/6/2025, whereby page 90,
It's 98 man.
98,
Minor.
not 98, 98 is the court's order.
Yes, man.
No, the first, what you said cancellation.
Oh, cancellation. Impugn order page 106. 106.
কি করলো? Not 26/6. This 22/12/2025. Issued by the Managing Director, Assam Fisheries Development Corporation. The grievance is also with regard to non-compliance of order dated 26/6/2025 passed in WPC 3612 of 2025 para. The learned counsel has, however, submitted that after filing of the filing of the writ petition, comma. Don't say after filing. That in the meantime, comma. After filing after filing, an order has been passed on 3/1/2026 by the Managing Director, AFDC, whereby the petitioner has been allowed to proceed in terms of the settlement order dated 23/8/2022 and the agreement dated 16/9/2022. The para Sri Bora, the learned counsel, has submitted that in view of the aforesaid development, comma, the substantial grievance of the petitioner has been redressed, full stop. However, the prayer with regard to the compliance of the order dated 26/6/2025 in WPC number 3612 of 2025 still remains para. Also heard Sri R. Chetri, learned counsel appearing on instruction of Sri P. Sharma, standing counsel AFDC para. This court is of the opinion that in view of the order dated 3/1/2026, comma, a copy of which is placed on record, comma, the substantial grievance of the petitioner appears to have been redressed, full stop. So far as the grievance relating to non-compliance of the earlier orders passed by this court, comma, the petitioner would have the recourse to file appropriate application in accordance with law. Para. In view of the above, writ petition stands closed. Para. Copy of the order 3/1/2026 is made part of the records.
Obliged, Bachchan.
6 months.
You does state counsel.
Master.
Yes. The award dated minutes 31/12/2024 has been challenged by this.
Award by whom? Which court?
It's the tribunal.
Hmm? Industrial Tribunal. What is the award?
The award lordship, see the order of reference that is 50 million.
Giving retirement
Yes.
prematurely.
Yes. But it was decided beyond the issues department. Beyond the issues department, it was decided by the
Where is the award?
award the page
Page
58 minutes.
58.
45 minutes. But findings lordship findings 56 minutes.
What are the directions?
Whether directing to pay the.
What is this award at 58?
Minute.
Of the earlier award of 13, what is it?
Yes, this was regarding their dispute regarding their regulation and application to get fee and get proportion. That was rejected. Here in this case.
Justified in giving. Your grievances regarding what?
Getting the payment of pensionary benefit. These are not regular employees. They have not entitled retirement pensionary benefit. SUD is entitled for the regular employment. Here, the industrial time directly.
See, the first issue has been decided in your favor.
Yes, madam.
That you are justified in giving the retirement. But you have been directed to give the retirement benefit. You are agreed by the other part.
Yes.
Who are the respondents?
1 and 2 matter of 1 minutes. Is the matter disturbed? One only.
Why have you made it? How can you make? See, how have you added the parties?
For diffusion of record.
No. That is okay. That you are required to do. Number one. How can you make two entities?
Yes, in the order of reference, this is.
That doesn't matter. You are in a writ proceeding. Josna Bhuya and Srimati Jamini Dekha.
As per order, we are made parties as per order of reference. The order also in this parties.
We have wanted, but notice will go to whom? How can it get two entities be in the under one respondent? And these are individuals. You should have made 1, 2, then the presiding officer is the third respondent. That is okay.
In the order of reference as well as in the labor.
So how does this court issue notice? Tell us.
We have no other
Why can't you make one and two? Two individuals are there. In reference, many things can happen. It has not been pointed out. Now, how do I issue notice? Notice will go to whom? That is not the question. Why are you going back? We have to think from this point. Notice will go to whom? One notice. They are individual workmen. How? Unless you make them separate parties, how separate notice would go? You file amended cost title by tomorrow. Okay? We'll issue notice. Tomorrow and make a mention, okay, file it today itself. Sri Iqbal, learned counsel. Sorry, Jahid, learned counsel for the petitioner. Prays for and is granted a day's time to file amended cost title with regard to the arraying of the respondents. Para. List immediately on filing of such amended cost title. If you do it today, tomorrow we can take it up. Yes, Mr.
The petitioner received an order for supply documents in Bangladesh. And accordingly,
One petition he had moved earlier. What had happened there?
it is pending because they have not filed the affidavit yet.
So this is a similar matter or what?
My problem is that, the amount has been returned back to the bank in Bangladesh. If the Bangladesh bank returns the amount, the dealer in Bangladesh, I will be nowhere because the amount has been.
Yes, Mr. Chakraborty.
I have for one only, Lordship.
Bank.
Lordship, I have instruction to appear in this matter. However, I have not filed my wakalat. There's a connected matter in the other writ petition. We have filed our affidavit today, Your Lordship. It was fixed.
When is it fixed?
It's fixed today before court number 15, Your Lordship.
Now they went back in adjournment, I think.
It's fixed on 13/2, Your Lordship.
13/2 will be a long time.
Lordship.
I must be protected because the amount which is there, if the gold me from dealer, I will nowhere, the amount will never come back. And I don't know, why they are saying that the Iranian sanction, the Russia, the sanction is there, all the export is being made. Iran, the export is made of the basmati rice, all those things. Where is the provision, that the US sanction will be applicable in India?
Mr. Bodler, you're for which bank? RBI?
ICICI Bank, Your Lordship.
ICICI.
Reference number 4.
This has been passed in another proceedings.
And on the basis that Bangladesh
Can you have a look?
return-
Lordship.
Are you aware of this order?
Yes, Your Lordship. Actually, we can keep the amount in a Nostro pool account, Your Lordship.
You can have it in escrow account or what account?
Nostro pool account.
What is it?
Directed,
Okay.
When comes from Bangladesh, should be accepted. If they have returned back,
In the other case, we have kept the amount in the Nostro pool
then
account. Your Lordship.
you have not kept the court directed, you return back. My total business is closed, not because the amount which I am due to get it, they are returned. In fact, I am ready to give any indemnity bond, any more property, the security they want. But if the amount is not returned, the bank, my business will be closed.
That matter is fixed on 13th.
13/2, Your Lordship.
Okay, we'll do one thing. You maintain status quo with regard to the amount.
Lordship.
Okay. And we'll have this on 13th.
They have returned, so status quo will not there.
Return to whom?
The Bangladesh bank,
Now, what kind of interim order?
the Bangladesh bank returns the amount, they should keep it.
Now, if they returns,
No,
is there any direction for the Bangladesh bank to return?
no, no. Says the If the above position provided that the pendency of the positions are should not be barred for the respondents banks, Bangladesh, however, it provided that the amount so received the prior to that much.
Okay, heard Dr. Saraf, the learned counsel for the petitioner who has put to challenge the action of the ICICI Bank, respondent number 4 of returning funds relating to export proceeds in favor of the petitioner to the remitting bank at Bangladesh. Full stop. The learned senior counsel has placed before this court an order dated 18/8/2025 passed in WPC 4691, wherein an interim direction has been granted that there would be no bar for the respondent bank to receive the amount involved from the originating bank at Bangladesh, which, however, has to be kept in a separate account and not released to the petitioner. Para. Let notice be issued, returnable on 13/2/2026.
For one only, Lordship.
Sri B. Chakrabarti, Learned CGC. What about Director General Foreign Trade?
I can take my register post.
That why can't you take your
They
CGC?
sometimes have their own counsel panel, Lordship.
Is it?
Or
One-
they may come to us also. They can come to us also, or sometimes they engage their own counsel, Lordship. Let notice go to them
Okay,
immediately.
one, and Sri G. Borderless Learned Counsel has submitted that he has instructions to appear on behalf of respondent number 4 and would file the power shortly. Para, let extra copies be served upon the learned counsel. Para, let steps be taken for service of notice upon the respondent numbers 2 and 3 by speed post with AD. Steps within 2 days. Para. Upon consideration of the facts and circumstances. No, 3. Dr. Saraf, the learned counsel, prays for an interim direction in the line of the order passed or of the order mentioned above. Para. Considering the facts and circumstances, it is provided that pendency of this writ petition shall not be a bar for the respondent number 4 bank to receive the amount involved from the originating bank at Bangladesh. Full stop. However, the amounts, if received, shall be kept in a separate account and not be released till the next returnable date. Full stop. The aforesaid direction would, however, be reconsidered on the next date.
You mentioned not a bar. Now bar means a discretion, and in the meantime, you don't.
We cannot, they are not here before us.
No.
How can we give a direction?
Right, then below. I'm asking for your also been given in direction that it will not bar for the respondent 4. No, respondent.
No, not a bar. We have said it is not a bar for them to,
No,
they'll receive it.
bar for them. Will not be bar for them, if the amount is given, they should accept it, Otherwise, it will discretion, they may accept, they may not accept, and the amount will go.
Is there any difficulty in accepting the amount?
Lordship,
They've already accepted in earlier case.
in the earlier cases, we have accepted, your Lordship. Now the
No,
problem.
don't say bar. But that was the order passed.
Well, but on that occasion, their good sense are prevailed, but now in this case, despite the order, so if the bank remit the amount, they should accept it, the amount will remain.
Why should they exercise the discretion of not accepting?
Well, if the amount is, they don't accept and the amount goes.
Bank will not accept an amount. It's difficult to.
No, I'm not, if the Bangladesh bank remit the amount, they should accept and keep in a.
That don't say penalty. It is directed that in case the originating bank at Bangladesh remits the amount, the same shall be accepted by the respondent number 4, which, however, would not be released to the petitioner, and whichever will be kept in a separate account and not be released unless, until further orders are passed.
According to the last paragraph, so.
We'll make it.
I am applying. Otherwise, the amount, the US sanction, amount will go, entire amount.
You said, why don't you settle these matters? It's only a procedural part.
Lordship, actually the bank which instruction I have received is that the goods were given to Bangladesh from a Iranian ship and from Iran. So Iran comes under the sanction list of the US, Your Lordship, and this ICICI Bank, they have their business in US and they have their shares in the US stock market. So that will be affected, Your Lordship.
Now, India below, in spite of the Iranian sanction and Russia sanction below, the oil import and export and the basmati rice is exported to Iran. If the.
Are you trying to invite Trump to the court? Let's not do that.
Not Trump, my lord, we will be following our banking, my lord, not that, my lord, there's something.
Let us not decide Iran here or discuss Iran here.
My lord, I don't want Iran or Afghanistan, anything, my lord. I want that whatever I supplied, I should get the money.
Okay, next please.
I'm pledging.
For this event, please.
47. Mishra? Yes.
It will be my suspension of supply, retail out of the petition.
Suspension of supply. What is the allegation?
Submit my lease date, my lord.
Lease. Mr. Chaudhary,
My lord.
have you stopped the supply?
Yes, my lord. We asked them to produce the lease deed, which is a requirement, and in spite of repeated communications, that has not been supplied, and we were compelled to, my lord.
What is your answer?
Petition pending, my lord. Petition is pending, they are the co-owners, my lord. Petition, that's why, otherwise also this, the land on which the petrol pump is running, my lord, it is in my possession, my lord, and it is in my share. It has not been disputed by the other co-owner and the fruit, my lord. They are accepting it, my lord. But since the fruit is pending, my lord.
Suit for partition.
Petition is pending. That is the only reason, my lord. This tax applies to the produce, my lord. The suit is pending, my lord. And since 2000.
Your lesser is a co-owner.
Co-owner, my lord.
And there is no dispute with the other co-owners regarding the ownership of the property
They have a
with your
title
lesser.
suit. They have a title suit, my lord, pending,
Title suit for partition.
my lord.
In 2022, I am running, my lord. In 2025, October, my lord, they have placed this, my lord. LOI is in 2019, my lord. And appointment was in 2020.
Is there any discontinuation order?
Yes, my lord, that order has been passed.
Where-
That
where is
that
it?
is impugned,
Page?
my lord.
Page?
158, my lord.
158.
Last year.
Now, my lord, difficulty with the IOC is that, my lord, under the petroleum rules, if you do not have the right over the land, the license has to be cancelled. We have not cancelled it, my lord. We asked them to produce the documents. They have not been able to produce it.
So how did it commission first? At the initial inception,
At the
he has to be equipped with a lease
True,
lease
true,
deed,
madam.
either a ownership deed or a lease deed.
Yes, my lord.
What did he produce? He's not the owner, he's the leaseholder.
He had no. He claimed to be the owner of the land, my lord. He claimed to be the owner of the land,
Petitioner.
my lord. And that document was never, my lord, placed before the my lord authorities. And because of the, my lord, in view of the petroleum.
Now what are you seeking?
That you produce the lease deed or your ownership document in respect of the land.
No, you say that he's a co-owner. There is no question of any lease deed then.
Co-owner, therefore, my lord, the other co-owners have to give their
Their parts
my lord.
on lease.
Yes, my lord. Or, my lord, no objection that.
No,
this-
we were slightly confused. We thought that he has taken lease from one of the co-owners. That is not the case.
No, my
He is also one of the
one of the
co-owners.
owners, my lord.
And now the issue has arisen that there are other owners of the land in question. Either the other owners have to give him a lease or
my
he
lord,
has to
no
produce.
objection, or no objection, my lord.
Yes.
They are given, my lord, initially, and my lord, since the page 29 LOI, my lord, they are admitting it that we are the co-owners and other, initially when the LOI is issued, my lord. NOC
See, Mr. Chaudhary, his client may not be concerned with these activities. What has happened? He needs a paper.
That is true, my lord. Since 2019, my lord, they have issued the LOI, my lord. In 2022, my lord, suit was issued, my lord, and we have apprised them, my lord. Now, my lord, the entire investment was made by the petitioner in establishing the petrol pump, my lord. The construction work, canopy, everything was issued by the petitioner.
How do you prima facie make out that you are the owner of this land?
That
What is the document?
Itself, my lord,
Which
page 29, my lord.
29.
29.
Yes.
Paragraph 1, madam.
Hmm.
Madam.
Hmm.
You have offered a suitable piece of land measuring so and so square meter and so and so square meter, madam. Covered by the Act number 147, pattern number 79, village, Kanika, Gaon, PO, Tesa district, Dibrugarh, owned by you, along with Sri Bodhin Gopal, Sri Jitan Gopal, Sri Minati Gopal, as indicated by you in the application for development of the retail outlet, madam. And I have also like the Ramamandi, madam. By way of inheritance, I have got this land, madam.
Oh, this was something which within your knowledge,
My
Mr.
lord, yes,
Chaudhary.
my lord, thereafter your lordship will read, my lord. Because what happened, my lord, one of the co-owners have died in the meantime, and that has led to the suit. And my lord, the requirement is that Minati Gogoi, as indicated by you in the application for the development of the subject retail outlet, you have to make available this land within 2 months from the date of this letter, failing which the offer is liable to be withdrawn. So, my lord, we did not withdraw it. We allowed them, but my lord, the document is yet to become. And if your lordship kindly sees the petroleum rules, my lord, the printout has been given to your lordship, my lord. That
No, we have seen, you have indicated in your offer letter that you gave him a chance to rectify, and this is of 19.
22, 1825, they have come up, my lord, and the food was in 2022, my lord. That is the only reason, my lord. And lordship will see the plan in the food, they are not disputing it, my lord. Co-owners, my
No,
lord.
they have given you more time. For that, you cannot find fault with them.
I'm not.
2 months, they had said, they had stipulated 2 months. And in paragraph 2, there is another, which Mr. Chaudhary perhaps rely upon for making the land available as required above. He will ensure that the land arranged by you is either registered in your name or it should be leased out for a minimum period of 19 years, 11 months.
My lord.
Those are stipulations.
And presently, my lord, we have been asking him again and again, my lord. And because of the pendency of the suit, my lord, this
How
matter.
soon can you make the amends?
I don't want to participate. I've already participated in the food, my lord. It may decide any time. Difficulty, my lord, cannot say how much time it may take. It may take 1 month, 6 months, and take this time.
It may take years.
See, they have the option even for cancellation. Till now, you have not been able to give the land.
You will see 2019 is LOI, 2021 appointment was given, 22, since 22 I am operating, madam. It's not causing any prejudice to the oil, madam. Any requirement.
It's not a question of prejudice. If there's a violation of law, the aspect of prejudice will come later. There's a violation of law.
We are also answerable, my lord.
My livelihood is involved, my entire life, my life.
Sri R.S. Mishra, learned counsel for the petitioner. Full stop. Please have your seat. The grievance of the petitioner is with regard to a communication dated 6/1/2026 issued by the respondent corporation, whereby the supplies to the retail petroleum outlet have been suspended with effect from 7/1/2026. Full stop. It is the case of the petitioner that pursuant to an allotment process, the petitioner was duly allotted the aforesaid outlet for which he had offered a piece of land. Full stop. The petitioner had declared that there were other co-owners of the land in question, and this fact was also taken into consideration by the respondent corporation while issuing the allotment. Full stop. However, the petitioner could not fulfill the stipulation of either having an appropriate order declaring him to be the sole owner of the land in question, or to be equipped with a lease deed for the land. Full stop. Sri Mishra, the learned counsel, has however submitted that he is running the business since long, and in the meantime, a title suit for partition has been instituted. Full stop. He submits that at this stage, if the supplies are suspended, comma, irreparable loss and injury would be caused to him, para. Let notice be issued returnable on 20th, 2026. Shri M. Sharma, learned counsel assisting. Shri Chaudhary accepts notice. Shri M. K. Chaudhary, learned senior counsel, accepts notice on behalf of all the respondents.
All this one.
All the respondents, extra copies be served upon him during the course of the day. Para. Shri Mishra, the learned counsel, praised for an interim order. Para. Considering the facts and circumstances and balancing the equities, it is provided that till the returnable date, comma, the impugned order dated 26/1/2026 shall remain suspended. Full stop. This court would, however, reconsider the same on the returnable date.
Obvious.
22. Basically, what is who?
Impugn order is that it's sixth.
Item 12.
Yes, you had made a mention in the morning.
Yes, Lordship.
All matters, 21 matters.
Although it is a 21 matter, Lordship, notices were issued in the year 2023, Lordship. So that is why, Lordship.
How does it matter when notices are issued?
Only 2 days time, Lordship. By tomorrow, Lordship, we will be
What is
filing
the
a-
matter about?
Lordship, they have claimed the salary that was deducted as penalty for resorting a strike, Lordship. So that is their claim.
Mr. Dasgupta, here for the union.
Yes.
Okay, but when can we have?
Any day. Get your lordship convenient.
We'll have it on Tuesday next.
No problem.
Okay, tomorrow we can, let us give him some time, and 27th Tuesday, we'll try to finish it off. While Sri A. Dasgupta, learned senior counsel for the petitioner is present, comma, Sri Sharma, what Sharma? What is your name?
I'm W. Rahman on behalf of Mr.
W.
Ishan.
Rahman.
On behalf of Mr. Ishan.
Sri W. Rahman, learned counsel, appearing in instruction of Sri A. Sharma has prayed for some accommodation, para. Considering the above, matter is adjourned to be listed on 27.
Deeply obliged.
1.
14, item 14.
Wait, Your Lord. Not
Mr.
in this,
Ram.
I'm appearing for respondent number 4, my Lord. I pray for 4 weeks' time to file my affidavit, my Lord.
Why haven't you filed your affidavit on
Lord,
this?
certain new development has taken place, my Lord. Otherwise, we are only a proper party in the matter, my Lord. Earlier, it was not required, Lordship. But because of
Yes, madam. Shri A. Lal, learned counsel for the respondent number 4 has submitted that due to certain developments, comma, it would be required for the respondent number 4 to place on record its stand. Who are you?
I'm the hospital where the line was taken.
It's 10, huh? It's 10 para. He accordingly prays for and is granted 3 weeks' time to file such affidavit. There are list on, we give a date. So long. 16th. 16 to, madam. Year for?
For respondent number 5, a petition.
You give your name. You does state council. You state council, you does and Miss Pri. Your name?
W. Ahmed.
W. Ahmed for APDCL are present.
I'm obliged.
May I please your lordship. Lordship, in this matter, lordship, the petitioner has approached this honorable court for the release of his pending. Lordship, during the pendency of this writ petition, lordship.
Public Works Department, madam. Availability. Who's there? B. Gogoi. S. Sharma, B. Gogoi. Mr. Chetia, just try to get. After a while. Affidavit has been filed.
Yes. In their
Admitted.
affidavit, they have stated
And
that.
Mr. Gogoi? Admitted.
Why not, that instruction is awaited.
No, you have filed affidavit.
No, my lord, in between, my lord, there's a direction that, my lord, both departments, my lord, NSM and my lord, PW will sit together and, my lord, clarify the issue. That part is evident, my lord. I have sought for the instruction.
Okay, we'll grant you short time
Yes.
then, okay? Heard Sri PP Medhi, learned counsel for the petitioner, para. Sri B Gogoi, learned AAG appearing for the PUWD as well as NHM.
Well,
However, prays for some more time to obtain necessary instructions in terms of the earlier orders passed by this court, para. In view of the above, matter is adjourned to be listed on 13th of February.
Lordship.
13th, try to have the instructions.
Lord-
We'll try to dispose this off. 1/6, yes.
For the direction, madam, for 1911,
What is this IA?
madam, for the direction of the Nadu court, madam, on 1911, madam, to implement the finance department as well as my treasury. The non-payment of contractual bill, madam.
Yes, let us copy.
Then we'll allow this.
Yes.
Heard Sri L. and Dihinya, learned counsel for the applicant of the grid petitioner, who by means.
May I have the instruction, my lord, why it is lying in the wrong head of account, my lord? That is the statement made by the.
No, we are passing orders in the IA.
Oh,
Include it.
well,
Who কি করলো? Has prayed for implement of the following party as respond number 6 and 7. That's a total. 1 and 2 করে দিব, হ্যাঁ এটা ইয়ার পরে দিব। Finance Department 1 আৰু Treasury Officer 2 ভিতৰটো থাকিব পাৰে। It is submitted. No, it is not. The learned counsel has submitted that the aforesaid entities are necessary parties. And an observation was also made by this court in the connected writ petition. Para. After hearing, comma, the instant I is allowed and the aforesaid entities are permitted to be implemented as respond number 6 and 7 in the connected WPC 2856 of 2024. Para. What do you call? In the main petition, you write an order passed today in IA number 3949 of 2025, comma, the following entities have been added as respond numbers, so and so. Now 1 and 2, huh? The learned Sri Dihinya, the learned counsel for the applicant, for the petitioner, is required to file amended cost title within a period of a week. After filing of the amended cost title, comma, this court would consider issuance of notice to the newly implemented respondents. Yes.
Can be closed. Number 5,
There's was paid.
Yes, your lord.
Heard Sri A. Ganguly, learned counsel for the petitioner. Also heard Miss M. Das, learned counsel for the respond number 5, full stop. Dara. The grievance of the petitioner was with regard to the aspect of compliance of the provisions of section 33C of the Industrial Disputes Act 1947 in terms of an award dated 29/20/22 passed by the Learned Labour Court, comma, Assam, in reference case number 01 of 2019. Put stop para. Both the learned counsel has, however, submitted that during the pendency of the writ petition, comma, the amount in question has been disbursed. Para, in view of the above, this court is of the opinion that there is no requirement or scope for any adjudication, and accordingly, the writ petition is closed.
When this certificate was issued, dated 1911 against it, that can be, she may say that is closed, otherwise it should be. In fact, this should be said by her, but
Since the grievance of the petitioner has been redressed, comma, there would be no requirement to proceed with the recovery certificate said to have been issued in the meantime.
Keep their beds.
18 years.
non-payment of contractual amount after completion of work.
Who's R8? R8?
Executive officer, my lord. Yes, my lord. We have reacted to file an affidavit, my lord, additional affidavit, my lord.
Have you filed?
We failed to serve the copy, my lord. Otherwise, I can file, my lord.
Give a copy to him.
Yes.
Okay.
Yes.
Heard Sri Upadhyay. You're Upadhyay? Adhyapak, sorry. You are SN Adhyapak. Heard Sri SN Adhyapak, learned counsel for the petitioner, as well as Sri M. Chetia, learned state counsel.
Respond number 8, my lord.
Learned counsel for respondent by 8, put stop. Para, Sri Chetia, the learned counsel has submitted that though an additional affidavit was required to be filed by him, comma, extra copies of the writ petition has not been served.
Affidavit.
The
Additional
copy of the affidavit has not been served. Para, Sri Adhyapak learned counsel for the petitioner undertakes to serve a copy of the affidavit during the course of the day. Well, yes, when? 3 weeks?
Any date, my lord.
Huh? List when? Tell us.
2 weeks, my lord.
9th?
9.
List on 9th. 9th February.
Probably.
Mr. Khan, the last order, it is 1/2025. Where the specific direction was given, the BTC to file affidavit within the 9th June and 9th January 2026. I think they failed, my lord. Personally, feel this matter for final disposal.
Yes. 25 matter.
Yes, sir.
What is the issue involved?
No. There is a case where Kendra Vidyalaya took the property from us under the aegis of BTC. But dues are there, that has not been paid. It has been
Whether
admitted.
for admission hearing? When?
Any date convenient, lodge.
But who has filed affidavit in the meantime? 3 to 6.
Yes.
2 has also filed.
Yes.
BTC has not filed or what?
No, madam.
Is your stand required?
No, we are very limited.
Then we'll decide on the affidavits.
Lodge.
We'll examine this aspect of the matter, okay, but since BTC has chosen not to file, it's up to them, okay,
That has given them.
okay. Heard, Sri H. Chamaria, learned counsel for the petitioner, who by drawing the attention of this court to the order dated 1/12/2025 has submitted that in spite of final opportunity, comma, the BTC has not filed the affidavit in opposition. Para. Sri M. Das, learned counsel appearing for the BTC, has submitted that BTC may not have a major role in the issue involved. Para. Also heard Sri Miss Udas, learned state counsel, and Sri, your name? Your name R. Chauhan. R. Chauhan, learned counsel for the spouse 3 to 6, who have filed affidavits. Para. In view of the above, matter is adjourned to be in view of the above, registry is directed to list this matter for admission hearing. When?
My lord, any date for suitable.
On 12th?
Well,
Thursday.
Obliged.
Amount admitted, my lord. I filed the affidavit, my lord.
Regarding what?
My lord, 34 lakhs.
Hire of purchase, hire of vehicles, or
My lord.
heard Sri L. Mohan, learned counsel for the petitioner. Also heard Miss Udas, learned state counsel, who has informed that the affidavit in opposition has been filed by the respondent 6 para.
Five.
The respondent
My lord, all my lord, 6, my lord,
Six.
6 as 5, my lord.
6 para. The grievance of the petitioner is with regard to a direction for release of outstanding dues for hire of vehicles, full stop. It is the case of the petitioner that he is the registered owner of vehicles bearing registration number. Okay, you can. Please. Which were hired. Full stop. However, the hiring charge amounting to rupees 34,42,128 have not been released. Para. The learned counsel has drawn the attention of this court to the affidavit in opposition filed by the respondent 6,
Paragraph
In-
5.
in which the amount claimed has been admitted. Para. Miss Das, the learned state counsel, has submitted that
Paragraph 5, my lord, page 48.
that we have said. Why haven't you paid?
My lord, that's a send for approval, my lord.
That
Sanction, my lord.
submitted that the issue has been examined, and on verification of the same has been forwarded for sanctioning. Full stop. Para. The stand of the respondent 6, which has been put in the affidavit, reads as follows, paragraph 5 of page 48, according to the para. The Honorable Full Bench in the case of Tamsher Ali has laid down the guidelines in case of a writ petition being filed for a claim for contractual dues. Full stop. Though a requirement has been laid down for an acknowledgement by the head of the department, in the instant case, the acknowledgement has come by way of an affidavit. Full stop. Considering the same, it is directed that the amount in question be that steps be taken for release of the amount in question in terms of the direction of the Honorable Full Bench in accordance with law. The petition stands closed. Stands disposed of.
So on behalf of ONGC, we have filed an affidavit yesterday. So whether they would like to file a response or not, I am not
What
sure.
is the challenge?
They want some,
Contract laborers were disengaged.
Contract laborers.
Were disengaged. In terms of the settlement.
So you have challenged the disengagement order
Yes.
in a writ proceeding.
Yes.
And you'd like to file a rejoinder affidavit.
Actually, I have got it today itself. Let the matter be fixed day after tomorrow.
Okay, you take the instructions. Day after tomorrow is a holiday, so we can have it on the next week. If you think that you need to file, rejoinder will grant you time.
If required, Lord.
If required, so we'll have it on Monday then.
Then
Monday we can. No, Monday is the holiday again.
in case in the first week of February, Lordship, first, second.
No, it's only for the purpose of giving
Okay,
him
then
time.
it is fine, Lordship.
If Mr. Rajgupta says that he is not willing to file any rejoinder, then we can fix a date for hearing.
Lordship. Highly obliged, Lordship.
Heard Sri Gupta, learned senior counsel. Also heard 3, D Learned Senior Counsel for the Respondent Corporation. Para. 3, Saikia, the Learned Senior Counsel has
State ONGC Council,
Senior Counsel has
senior, I'm sorry, I heard state.
Senior Counsel has submitted that the affidavit in opposition has been filed yesterday,
Yes,
which however is not tagged with the records. Para. Sri Dasgupta, the Learned Senior Counsel for the petitioners, praised for some time to obtain necessary instructions on the requirement to file any rejoinder affidavit. Para. As agreed to by the Learned Counsel for the parties. List on, matter is adjourned to be listed on
Wednesday next lordship,
28.
28. Highly obliged.
If you require time, we'll grant you time for filing.
Three mile,
Who is free?
Union of India,
Okay, name?
Jay Sharma.
Ms. J. Sharma, yes, CGC. Okay.
Obliged.
They have to take final decision on the representation filed by the petitioner as per order of this.
And that instruction is awaited. I have communicated, madam. Also, we'll see order dated 3/12.
Yes, we have seen that.
I have communicated, madam, that is awaited.
We filed a representation on.
Now, has it been disposed of? Has it been considered? Not considered. Okay.
We
Hertz
filed
Free,
a representation on 16/12/20.
Hertz Free BD Das, Learned Senior Counsel, as well as Sri B. Gogo, the Learned Additional AG. Para. The Learned State Council has submitted that though that in terms of the order dated 3/12/2025, a process is underway for consideration of the representation. He, however, prays for some time to obtain necessary instructions with regard to the outcome of such consideration. Para. When?
After 3 weeks, madam.
Not 3 weeks.
2 weeks, madam.
In view of the above, matter is adjourned to be listed on 11th of, okay?
Lordship.
11th of February.
Let me 13, madam, at least I will get.
Okay, 13th of February.
Yes. Obviously.
Item 25.
25.
This is regarding blacklisting, my lord, the losses that granted some time to the member. If a lawsuit will see, my lord, the clause for blacklisting, my lord, it's that page whatever.
Now, who has filed the affidavit? You have filed
I have filed affidavit.
today,
Yesterday, my lord.
yesterday. I'd like to file a rejoinder.
Because this is covered judgment, my lord, and covered case, because recently one judgment has been delivered, and otherwise also it is covered by Supreme Court also.
Yeah, what do you say? Is it covered?
Covered.
My lord, regarding one issue, my lord, because there is two department. One is product department and one is farm department. So the petitioner is contending that before going for the farm department, there should be the product department. The relevant clause, my lord.
No, we are not on those. We are on the principles of blacklisting.
Yes, my lord.
Did you give opportunity?
Yes, my lord. Enough opportunity was given to.
You have met with the requirements of Irrigation and Gurkha.
Yes, my lord. Enough opportunity was given, my lord.
Here your losses has to see, my lord.
And in fact, even after
Then
filing,
we'll take it for final disposal on Tuesday next.
even after, my lord.
Tuesday or Thursday next.
Any tenders are there, because your losses last time, will be.
No, understood. They have filed the affidavit. We'll take it for final disposal either on Tuesday or Thursday next. Today it may not be possible. There are many matters.
My lord, the next week I will not be here, my lord. So, my lord, I pray, my lord, that your losses will consider, because what my lord says, this law itself says, my lord, first thing, my lord,
Mr. Sahiwala, today it may not be possible. See,
No,
we have
I
not.
don't say, interim, my lord.
No, not question of interim after exchange of affidavits. We'll dispose of the matter.
Yes.
You give a date of your convenience.
So your losses, my lord.
We pass interim orders when there are no response filed or on the motion stage. Here, response have been filed. How can you ignore this response?
Response, my lord, on the face of it, my lord.
No, we'll have to go through this. See, this has been put on record today. We have not even gone through.
No, that is not, my lord. Your losses may see the original thing, my lord, because.
Mr. Sahiwala, that is your perception. He has put something on record. Aren't we required to go through it?
He has done somewhere else, my lord. Because that context.
Where he has gone, where he has not gone, we do not know. We have not gone through this. This is put on record in this court. It was not identified. Let us go through it. You give a date of your convenience. Maybe next Tuesday, next Thursday, whenever it suits you. 2nd of February. No, don't say. Huh? Third is third Tuesday. Yes, third is good. Can you record that you are not going to file a rejoinder affidavit?
No.
Heard through GN Sayal, learned senior counsel for the petitioner. Also heard through DP Bora, learned for which health department?
Yes, my lord.
Learned standing counsel health department, who submits that the affidavit in opposition has been filed yesterday, which is tagged with the records. What is this additional affidavit, Mr. Sayala?
My lord, myself. with
You also filed additional affidavit.
Yes, my lord, this Honorable Court, acted me.
Okay, okay.
That's my lord.
Okay, yes. Sri Sayala, the learned senior counsel, has also submitted that an additional affidavit has been filed yesterday, which is on record pertaining to the aspect of the tenders, of the new tenders in the pipeline. Para. Both the learned counsel submits that the matter can be taken up for disposal at the admission stage. Para. In view of the above, list for admission hearing on 3rd of February 2026.
Obligement.
Again, 48 of this.
Forty-eight. Yes, Mr. P.K. Mazumdar. Madam, new, what is
Yes,
this?
madam.
Irrigation department?
Yes, Your Honor.
You have filed an affidavit?
Yes, Your Honor.
When?
I filed affidavit on 8/12.
8?
8/12, my lord.
8/12.
Yes, sir.
And appears for the petitioner on call, Miss D.S. Newg, learned standing counsel irrigation department has however informed that the affidavit in opposition has been filed on 8/12/2025, which however is not tagged with the records para office to verify and tag the affidavit said to have been filed by the department. Full stop list on 11th of February.
Deeply open.
49 to 53.
But here, my lord, I have been entrusted to look into this matters by the government office from 48 to 49 to 53, my lord. I prefer some time to file the affidavit. Otherwise, union has filed the affidavit. I prefer some time.
Okay, what is the issue?
In the subsidy matter, interest subsidy, the issue is otherwise settled, what had happened,
Subsidy regarding what?
central comprehensive insurance scheme. Reimbursement of the insurance premium.
Okay,
There was
that comes as a scheme under the subsidy scheme.
under subsidy.
You say that you are entitled to it.
I'm entitled. What had happened, Lordship? There was a two scheme, 1997 and thereafter 2007. My period covers under both the scheme. And there was a change in mechanism of how the scheme will process and how the process will be done. In the earlier scheme, it was under the insurance, national insurance company.
Okay, then let the state file the affidavit,
Yes.
then we'll.
Yes, only the issue
How-
pending is like.
How soon can you file?
Well, 3 weeks, my lord, I will file.
Oh.
Yeah.
Heard Dr. A to the learned counsel for the petitioners. Para. Also heard Miss Amdas, learned counsel appearing on instruction of Sri S.K. Mathis, learned CGC for the Union of India. Para. Sri B. Gogol, learned AAG, Assam, has submitted that he would appear for the state respondents.
My lord.
Full stop. He prays for and is granted 3 weeks' time to file the affidavit in opposition. Para list on, give a date, Mr. Gogol.
My lord, after 3 weeks. Last week of February, my lord. Before that, I will try to file.
On 20th, this February, okay?
Obligation.
54.
Fifty-four, madam, who's for the petitioner? S.C. Das. E. Buragohan. . What the instructions, madam?
Lordship, although notice was issued, however, since this is a non-payment case, there's no admission, there's no admission from the head of the department. In similar cases, your lordship had asked the petitioners to bring on.
None is there. None appears for the petitioner on call. Tara. Miss M. Kodita, learned pending counsel PHE has however submitted that though notice was issued on 29/10/2025, the matter pertains to a claim for contractual dues and there is no acknowledgement of the liability by the head of the department, which is a requirement as laid down by the Honorable Full Bench in the case of Tamser Ali versus so-and-so, reported in so-and-so. Be that as it may, in absence of the learned counsel for the petitioner, matter is adjourned to be listed on when? 16th of February.
Obliged. Your Lordship.
85. Yes, Mr. Sharma.
Lordship, this matter has become infractious, my lord. This is the instruction.
I am the highest bidder, but settlement was given to the third bidder.
It was cancelled with the third bidder and the petitioner, the settlement was made to, with the petitioner. This is the instruction dated one.
This is not instructors. The settlement has been given to you now.
Yes, madam.
I have been denied of settlement.
No, that is the instruction.
It is.
Or presently.
Yes. Heard Sri K. Sharma, learned counsel for the petitioner. Also heard Ms. What?
B. Bora, madam.
B. Bora, learned standing counsel.
BTC.
Yes,
Yeah.
Goro.
Or
Correspondent number 6.
who is 6?
Private respondent.
For Ms. You does, I would believe, you does state council, Ms. B. Bora, standing council BTC and Ms. S. Boro for the respondent number 6, para. The grievance of the petitioner was with regard to the action of the BTC in cancelling.
Yes, my lord. Cancel.
Cancelling the settlement of the market in question with him and rather giving it to the respondent number 6. Full stop. It however appears, Ms. Bora, the learned standing counsel has however submitted that during the pendency of the writ petition, the grievance of the petitioner has been redressed and the market in question has now been settled with the petitioner. In this connection, she has placed before this court a written instruction dated 8/1/2025. Full stop. Para. In view of the aforesaid instructions, this court is of the view that there is no live cause of action to be adjudicated, full stop. Accordingly, the writ petition is closed. The written instructions dated 8/1/2025 is made part of the reports. Yes, it is needless to state that consequential action pursuant to the instructions be taken expeditiously. Yes, Mr. Chaudhary.
It's for non-payment of contractors' fee also. Amount of it is 3,91,000.
Admission, acknowledgement,
Statement of liability is case 40.
40.
40.
Who has signed?
Executive engineer and the accounts. What got done was issued. And it was.
We have not said that you are not entitled, but we are saying that writ court will not be the appropriate forum for adjudication. Why should? You follow terms early, we are here to protect you. If we entertain a writ petition in spite of a full court, what is the necessity of having a full court? Full bench has said, head of the department, specifically mentioned executive engineer is not the head of the department, by not less than in the rank of a chief engineer. There are matters where somehow notice has been issued, there are affidavits admitting, in those cases we have said, we are only aspect of, these are factual matters. You need to go to a civil court. You cannot bypass, you cannot burden the writ court like this. Madam, what do you say?
My lord, I have not seen instruction, my lord.
You try to have the instructions. If you are raising any dispute, then we'll have to close this. If you say on record, we'll not say anything now. Otherwise, you are required to have something more. We are being, new matters we are not entertaining unless there is an acknowledgement by the, in the rank of the chief engineer. No notice was issued on 29/10/2025, Miss D.S. Neog, London Standing Council. PHE, irrigation, submits that instructions are awaited. Para, in view of the above, matter is adjourned to be listed on 16th of February to enable the London Standing Council to obtain necessary instructions. 57.
Last order.
Amendment, the IA is for what, madam?
The respondent number 8, because the respondent number was made partly without any. Presented by the.
Post agreed. Okay, we allow this, madam. But this, was there any observation made in the writ petition, madam? Was there any observation made in the writ? That is, was there an observation? Only verbally. Which order?
Right.
Which sheet? 1612. Huh? 812. There's no such. No. Okay. Not required as such, but okay, you're fine.
Because
Hard.
there is some chaos, whether the Parghat was falls under Dhubri Municipal Board or Folimari GP.
You have filed your affidavit.
No, Lordship, we have already sent a letter to the circle
You
officer for
take the
deputation.
take the instructions, file your affidavit. In the meantime, we'll allow the IA.
Lordship.
Heard Miss S. Roy, Learned Counsel for the petitioner, for the applicant, who by means of this application has sought amendment, has sought for amendment of the cost title. So far as cost title, more particularly with regard to the description of the respondent number 8, full stop. She has submitted that the respondent number 8 was described as so and so, huh? It is described as so and so, which put however, the said respondent number 8 should have been described as so and so, not anything. Existing. Para. Considering the facts and circumstances, comma, the instant I is allowed and the description of the respondent number 8 as prayed for is permitted to be changed as indicated above. Para. I stands this paragraph. In the main writ petition, you write, an order has been passed today in I number so and so, permitting to amend the cost title so far as the respondent number 8 is concerned. Full stop. The Mr. S. Roy, the learned counsel for the petitioner, is required to file amended cost title within a period of a week. Okay. When do we fix the date?
The municipal corporation without any authority is making the construction.
Tell us date.
For-
List on 11th. List on 11th. Madam Chaudhary for whom?
And for respondent number 5, preceded compulsory.
File affidavit.
No, Lordship.
You filed your
Yes,
affidavit.
this matter was
And
disturbed by
Bora?
instruction. Lordship.
You also filed your affidavit. At least get the instructions. On the next date, comma, the learned counsel for the respondents are directed to obtain the instructions.
No, Lordship, you can keep it in 12 May,
12 is a Thursday.
then 11.
11 or 13th we can have. 11th.
Obliged.
I had to dispose of Kodiba.
26.
Yes, contempt pending since 18. Why?
Your Lordship, kindly query the last order, 10th of November. My brain got budget.
Yes, where is Mr. Borpujari? Is he there in the court? Mr. Borpujari? Please call Mr. Borpujari, madam. R. Borpujari. Mr. Hussain, after a while. 18 matters should not be kept pending. We'll try to have some. Please call him. Yes, next.
The Lordship, as per last order dated 8/1/2025, service upon respondent number 5 is completed, Your Lordship. My Lordship, kindly take it up for admission here, Your Lordship.
18 matter. What is the matter? Subject matter involved. What is the subject matter?
Lordship, it is regarding cancellation.
Cancellation of?
Purchase order, Your Lordship.
Okay, we'll have immediately then. You heard Ms. K. Sharma, learned counsel for the petitioner, who has submitted that this court on the earlier occasion, i.e. 8/1/2025, had made an observation regarding completion of service upon the respondent number 5. Para. Upon perusal of the same and considering the facts and circumstances, including the aspect that the petition is of the year 2018, comma, list for admission hearing on this tarikh, 29.
29 January. Okay.
28.
Yes.
This is the non-payment of bill.
May I please, your lordships, I'm appearing on behalf of R.B. Bora. She is not well today, lordships. That's why.
Are we okay?
Yes, lordship. She's suffering from spondylitis.
Okay, some other day, okay. While the learned counsel for the petitioner is present, what is your name?
A para, sir.
While Miss
R.
A. Parasar, learned counsel for the petitioner is present, comma, a prayer for adjournment has been made on behalf of Miss R.B. Bora on medical grounds. Paras, considering the above, matter is adjourned, will be said on 9th of February.
So, yes.
9-2.
29, 29, 30, item 31.
Same.
Same law.
29.
28.
You are also
30,
appearing in those matters.
20.
29, 32, same order. Please get the dates. Lisa, number get up. Please, madam, again, 29. Okay. Oh, and same prayer you are making in all these cases?
That's it.
Okay. That to call it 30 to 3.
Lordship, these are series matter, Lordship, 28 to this 37, Lordship. In some matters, there is 28, 29, 31. RB Bora was appeared and they have taken time. So all this matter may be fixed along with she appeared.
Okay, you were there, madam. And Parasol was also there. Where is Parasol? He was here, right?
8 to 36.
Lordship, in item 30, they have also appeared in the last occasion. Therefore,
We'll have together along with those matters. Okay.
20.
List on key did you? Huh? 9-2 along with switch, huh? Together.
31 and 36 and
Oh,
31, 36.
okay.
Yes.
এটা তো নামটো পড়াশা নাই তাহলে ভুলতে পড়াশা দিয়েছিল
In this matter, Lordship, I am appearing for this newly added this contempt now, Lordship. I am praying for some time for instructions, Lordship. We have waiting for item 37.
One 12, you were given a final opportunity, madam.
Lordship, for 1 week time, Lordship, we will take proper instructions.
It is observed that if no affidavit is filed by the next date, court will be constrained to pass appropriate orders for final personal appearance.
Lordship, final opportunity may be given.
Final was granted already, madam.
Lordship, we have tried.
Before you make this kind of a submission, you have to go by the order of this court. Not only final opportunity, there is a stipulation of a personal appearance if no affidavit filed.
Lordship, 1 week time, Lordship.
It's not like that. Don't take things for granted. Where is an application for time? Have you filed any application for time? There's an observation of personal appearance. Ask your client to appear. Don't take things for granted in the court. Who's the respondent?
Respondent number 1.
Who?
Don't they have filed an affidavit, my lord? Lordship, they have letter.
We are going by the last order.
Yes, ma'am.
Who has filed affidavit?
Respondent earlier has filed one affidavit. Perhaps a clarification has been sought for, my lord. Whether, my lord, the PTC, my lord.
Madam, you have seen the last order, 1/12/2025.
Yes, Lordship.
What is it?
To take further instruction regarding clarification.
Final
of the-
opportunity is given to the respondent number 1 to bring on record their standby of an affidavit list on 21/1/2026. That was a passed on 1/12/2025. Just remember.
Lordship, and in between, Lordship, this Akashdeep was again, it was other person was take over the charge. So because of that, Lordship, some.
So what will happen to the court's order?
Lordship, 1 week time.
What will happen to the court's order? Have you filed for review? Then court's order needs to be complied with.
Yes, Lordship.
You file on 27th. File on 27th. If you do not file on 27th, we will make an observation regarding your personal appearance.
Right, 27.
Heard Sri B. Das, learned counsel for the petitioner. Also heard Miss M. Chaudhary.
And so,
N. Chaudhary, learned counsel for the respondents. Para. On the last occasion, that is 1/12/2025, the following order was passed. Please quote the order. Para. Sri Chaudhary, the learned counsel, has prayed for some more time. Para. This court has however noted that neither any application for review nor for extension of time has been filed qua the aforesaid order dated 1/12/2025. Under those facts and circumstances, this court is of the view that the observations made earlier cannot be allowed to be obliterated. Para. As an exceptional circumstance, time till 27/1/2026 is granted to file the affidavit in terms of the order dated 1/12/2025. It is however made clear that in case the affidavit is not filed, the response number 1. Response number 1 shall remain personally present in this court at 10:30. Full stop. Let a copy of this order be served to Ms. Chaudhary during the course of the day, and there is no requirement to serve a formal notice to the said respondent number 1, who is already represented.
obliged.
Madam, collect the copy from the court.
Can you see the few order? There
Yes.
were two-fold direction. First fold is that, madam, so far the honest money is concerned, that has to be released. That's now under process, madam. We have approached reported by virtue of the order passed by this honorable court.
Yes, what do you say, Mr. Gogoi?
On the last occasion, he was asked to go before the authorities to
Yes.
collect this.
We have collected.
They have collected, your lordship.
Now,
That is,
second
so
part is
now that it's under process for release of the EMD.
Second part is important. So what happened, my lord, there is a two-fold direction. First, we release the earnestment. Second part is that the direction this will, according it is ever directed the respondent office that release the outstanding dues of the petitioner in accordance with law after due verification within a period of 1 month from the date of receipt of the certified copy. That means my claim.
What have steps have you
Now,
taken,
there
Mr.
is-
Gogoi?
Lordship, there is no outstanding payment
Exactly.
due to him, your
Only
lordship.
one, well, in their.
Where have you stated that?
That affidavit we have not filed, but we had only filed regarding,
You file an affidavit?
yes,
Affidavit they file, my lord.
we have
No,
filed
no.
regarding this.
Affidavit with regard to the fact that there is no outstanding according to them. You need to be given a fair chance.
Exactly, my lord.
Let them
Details
file
they have to
affidavit.
place, details.
Detail will
Heard
place, your lordship.
Three S summary alert.
My lord, because my lord, in our rate petition, we have enclosed each and every bill, etc., which they have also. Lord, you can't claim that.
Heard Sri S summary learned counsel for the petitioner. Also heard Sri R Gogoi, learned counsel for the respondent number
Respond number 1, your lordship.
1, full stop. Sri Gogoi has informed that during the pendency of these cases, the matter has been examined and the aspect of earnest money
Earnest money is under process. Because he has appeared before the authorities.
examined in presence of the petitioner, and the same is under process. Full stop. He has, however, submitted that so far as outstanding dues
Yes,
are concerned, no such outstanding dues are found to be pending. Full stop. Let the aforesaid aspect, since the second aspect has not been brought on record, to give a fair opportunity to the petitioner, let the same be put on record by way of an affidavit.
Very well, lordship.
My lord, in detail, my lord, because what
Affidavit.
examination. they have
Just,
done-
how soon can you file, Mr. Gogoi?
Uh,
List on 16th?
16, yes, your lordship.
List on 16th. Prior to his date, the affidavit is required to be filed.
Only one line, my lord. Otherwise, my lord, my claim will go that the process of verification, what verification they have not make.
Verification is to be done when there is pending bill, when there is no.
Brother, let me complete.
We cannot verify.
File this, we'll see. Let you file.
All right, lordship.
Lordship, can it be called that rate petition which will dispose of the entire documents are there, man? The list I can place, man. It
Let
will
him
help.
file the affidavit, let's see what he says. Next. Yes, yes. You're appearing
On behalf of S. Datta Lordship.
on behalf of respond number
4.
4. You filed your affidavit. What about the other respondents? Served or not? Produce the office note dated 15/12/2025. Full stop. Miss P. Thapa,
Lordship.
Learned Counsel has entered appearance. Have you entered appearance, or Mr. Doctor? Let's Miss P. Thapa has appeared for the respond number 4 on behalf of 3 S. Doctor and pressed for time to file the affidavit in opposition. Para. List on 18th of February to enable filing of such affidavit. Full stop. Office is also required to to provide a fresh service report regarding the other respondents. Mr. Kyle?
My lord. My lord, there is an order passed to the Supreme Court. These applications may not be maintainable, my lord. I'll just pass it off to my lord.
I know about the also. The initial order was passed by pages. The subsequent order is by two.
No, there's a clarification. It's based on a judgment of the equal strength. And we'll just finally have this order.
There is a specific.
The review is not maintainable.
Yes, my lord, review is not maintainable. Some order.
I know.
One of the reviews were directed in terms of para 7 of the judgment. And I'll finally come to para 4 of it. This was passed, my lord, based on.
What is the principle?
Well, the principle is, this is the judgment of the.
Original, Rathi?
Yes,
Doesn't matter. What does it say?
Para 104, my lord, it's categorically held that we hold.
We'll just have a. We'll come to you. 104,
my lord, at page 24. No review is available upon a change or reversal of a proposition of law. Under 104, we hold that no review is available upon a change or reversal of a proposition of law by a superior court or by a larger bench of this court overruling earlier exposition of law, whereon the judgment or order under review was placed.
Okay.
But see, here petition is different. You may come to page 23.
23.
Yes.
Of?
My review. Paragraph 6.
23.
Page 23, paragraph 6 and 7. Very good.
Yes, 6 and 7, yes.
Hence, to the consistent validity of the statutory provision cannot be adjudicated upon the absence of any lease and contract between the parties. We accordingly allow the review petition and impose the judgment area so asking the development limit so stand restored to 5 for the phrase adjudication before the bench nominated by the Chief Justice of India on the administrative side. The next paragraph. Where any other proceedings have been disposed of by relying on the judgment of this court in Ganapati Telecom so denoting granted to the right parties to seek review of the present judgment. So Lordship, the proposition submitted by my learned friend is on the that judgment was set aside. Here judgment was recalled. And liberty was granted to the aggrieved party to come with for review.
But this order
4th November.
passed in Ganapati, Dilcom by the Honorable Supreme Court, 3 judges bench. The subsequent judgment has taken into consideration the earlier case of Rathi, which was also of equal strength, was not taken into consideration. And therefore, in the case of Virendra, though it's a 2 judges bench, it has given reasons that is not agreeing with the observation. How do you reconcile? Huh?
So decide.
No, see, Honorable Supreme Court has maybe a strength of 2 judges bench has taken into consideration the earlier.
First by three bench judge.
Yeah, earlier Rathi was also 3 judges. It was not brought into consideration, not brought to the notice. Which one, Parinpuriam? No, Ganpati, then you are relying on Ganpati of the.
No, because petition was disposed of on the basis of Ganpati. Petition was allowed. Lordship, Supreme Court subsequently taken the review petition was filed. Then Supreme Court come to a conclusion that the outcome cannot be decided when it is not been checked. So that has to be taken into consideration whether.
No, that the observation is different. Observation which you have just relied upon is said that unless where is it?
Page 23.
A challenge to the constitutional validity.
Provision cannot be delegated upon in absence of any lease and contract between the parties.
There was no challenge.
No, Lordship, yes, in the Ganpati Lordship, there was no challenge. When it was decided in favor of the petitioner, then the entire dynamic resolution was set aside. The provision of 1988 was set aside. Then Lordship, review petition was filed by the department. Then this judgment came and liberty was granted to the.
We'll decide this on some other day. We'll apply some mind. You give the yes.
Otherwise, the standard is pretty clear.
Yes, we'll consider. Mr. We need your assistance, Mr. Kyle. Have a look because you may be right in contending that this Virendra, but Virendra has given good reasons. And
I'm aware of that.
okay, when can we have? We can have it on third discord may not be there. On 29th?
Not it is between the month of February.
February first 2 weeks don't give. First 2 weeks this court may not be here.
10th of February.
Or is it tagged to this court? No.
No. So Lordship, there are 3.
Oh, it's a review petition. Oh, it's
Lordship,
tagged.
it's tagged to it.
Tagged, yes. Okay.
Okay.
Then we can have it on 17th.
Lordship.
17th, okay. Heart free SC Kyle. Learned counsel for the petitioner, for the applicant, as well as your A. Sandila. A. Sandila learned counsel for the respondent numbers 1 and 2. Full stop. Sri Sandila, the learned counsel has submitted that the present application for review would not be maintainable in terms of the order passed by the Honorable Supreme Court in the SLP number 8229 dated 4/11/2025. He has also submitted that in the said case, the Honorable Supreme Court has taken note of the earlier decisions in the case of Union of India versus Masters Ganapati Dilcom Private Limited, as well as the the case of Government of NCT of Delhi versus KL Rathi. Rati, what is it for? Steels. Steels Limited. Reported in 2024, 7 SCC 315. Para? Para, the matter would require some deliberation. As agreed to by the learned counsel, but for the parties for consideration on 17th. Okay, we are retaining this two copies. Okay?
May to your lordship. Well, this liquidation challenge is an order by which the petitioner has been technically disqualified in the tender process. May I implore your lordship to read the last order?
So we said that we'll have to, make an endeavor for disposal. We can have you filed your affidavit? We have it for disposal?
Well, tomorrow is the price opening bid.
Yeah, that is why disposal.
Yes. Yes, yes.
You don't want a disposal today?
No, today itself, today. I'm so
Sir.
sorry.
I'm preparing for number 3.
Number?
Respondent number 3.
Okay.
In persons to my lord, on bills to.
You wanted it to be allowed.
The assembly number 3 is the my lord.
Yes, please narrate the facts, Mr. Chaudhary.
My lord, the NIT was in respect of, if your lordship kindly comes to the NIT, my lord, at page 33, my lord, it starts at page 33. 34, my lord, narrates the work.
NIT is dated?
NIT is dated 25/7/2025.
Page 33.
Starts at page 33. I'd like to draw your lordship's attention to page 34 minus one sentence.
Yes.
Messrs. Technic Engineering India Limited, that is the restaurant number 3, my lord, which is the project management and consultant of restaurant number 2 NRL. And the project management consultant on behalf of Messrs. Numoligo Refinery Limited owner NRL invites bid for execution of EPCC engineering, procurement and construction and commissioning package comprising balance of plant works for LPG marketing terminal. Now, my lord, I am my lord pressing on the word balance. That my lord indicates that there was an earlier contract and my lord that was not concluded. Then my lord they had to re-advertise for the balance work, and this my lord NIT in respect of the balance work.
Yes.
Now that the tender conditions which are relevant for the purpose of the present petition, your lordship will get my lord at page 37. 37.
Yes.
.1. May I read it, my lord?
Yes.
Technical experience criteria. The bidder must have successfully completed at least one engineering procurement and construction EPC, engineering procurement and construction and commissioning EPCC / lump sum turnkey basis LSTK contract on its own with single point responsibility involving project management, design and residual design and details engineering, procurement, construction, pre-commissioning and commissioning assistance during the last 15 years ending the last day of the month previous to one in which the original bid due date falls for any one of the following: A, LPG marketing terminal / LPG dispatch terminal, either or, involving LPG gantry and associated offsite utilities which may or may not include LPG bulk storage facilities, or any process unit in hydrocarbon sector refineries or petrochemicals or onshore gas and or oil processing facility or offshore gas and or oil processing facility or fertilizer sector, fertilizer plant. Now, my lord, this is the requirement I fulfill. I'll show the lordship thereafter, my lord. Then your lordship may kindly come to page 42. Because my lord, there are two criteria they have to consider. One is that my lord, technical experience criteria, and the other is the commercial experience criteria. That your lordship finds at page 42.
Yes.
There, my lord, 10.3.1, the bidder should have past experience of having successfully completed similar works during the last 15 years, ending last day of month previous to the one in which the original bid due date falls, should be either of the following: one similar successfully completed contract valuing not less than the amount equal to INR 140 crore. Then B, two similar successfully completed contracts, each valuing not less than the amount of equal to 112 crores. C, these are all my lord. Three similar successfully completed contracts, each valuing not less than the amount equal to INR 84 crores. The above valuation of completed contract shall be exclusive of GST service tax. Similar nature of job shall have the meaning as set out in clause 10.3.2 below. Bidders to submit documents in support of the commercial experience criteria as outlined in clause 10.4 below. Then, my lord, your lordship may also read page 43.
4-3. Yes.
10.4.1, your worship. I am skipping the not necessary.
Yes, yes,
at
please.
this point of time. For technical and commercial experience criteria. For technical experience criteria, bidder shall furnish documentary proof in the form of copy of work orders / contract agreements / relevant pages of contract documents mentioning the scope of the work, along with the completion certificate. Well, this is important. Issued by the owner consultant, approved design, drawing documents or any other certificate issued by the owner. Now, my lord, these are the basic requirements, my lord, which I have to fulfill. And my lord, in order to show that, my lord, I fulfill this requirement, my lord, I have annexed 3, my lord, work orders. I'll, my lord, refer to those orders.
The stand of the refinery or the authority, you fail in which one of this?
My lord, in fact, they say, my lord, technically. Technical, the first one, my lord.
Page 37.
Technical experience criteria.
Page 37.
My lord. And therefore, my lord, they have not gone into, my lord, the other criteria of
Commercial.
Commercial.
Not, then you need not go to the aspect of commercial. You can try to confine your arguments to the decision making, which is on the aspect of technical holding you.
Yes, but at the same time, my lord, I'll satisfy your worship, my lord, but I will fulfill my lord.
Now, since they have not even exercised their mind on the other aspect.
Now, the question is, my lord,
yes,
both these aspects are to be considered together.
Okay.
For the purpose of deciding, my lord. Now, here they say, my lord, because this is along with the completion certificate, that part, my lord, they are ignoring. My lord, what I am trying to, my lord, satisfy your worship on is that the action of the authorities, it is either arbitrary or there has been non-application of mine, or, my lord, it is malafide. So, my lord, I'll refer my lord, to the work orders, which will, my lord, show that these, my lord, requirements are fulfilled.
Page?
The work orders are at, my lord, page 68, 81, and 117. The first order, my lord, is at page 68.
To show your experience.
No. In fact, my lord, this is regarding experience. That your lordship may skip for the time being, my lord, since your lordship has said, my lord, we will not go into the experience part.
No, no, they are on the experience part only, not on the commercial part.
So there.
The disqualification is on which criteria? Non-adherence or non-fulfillment of which criteria?
My lord, they said that we are not, my lord, all these three documents that we have, my lord, submitted in support, my lord, they do not fulfill the, my lord, on the criteria. That is what.
Let us see the impugned order. I think it will be, let us see the impugned communication.
My lord, the impugned order, your worship will find that page 171.
171.
Well, it's a very long order. If I leave that, my lord, there's.
You can just.
Yes, my lord. Now, 171, it starts, my lord. The relevant portion, I may draw your lordship attention at page 175. Page 175, your lordship may directly come to the last paragraph, 7.
175.
My lord. Clause 7. May I read that?
Yes, please.
The work orders and corresponding completion certificates provided by you were issued by three entities, that is IOCL, SHB Energy Private Limited, and NGC Energy India Limited, India Private Limited. Following is the crux of evaluation of the technical experience criteria documentation provided to you. Then, my lord, they have discussed about the work order number 1.
Yes.
And my lord, the finding your lordship will find at page 176.
Yes.
The technical review. That sentence, my lord, technical review, your lordship may kindly.
Yes.
peruse. As per the scope of the work, whether scope was limited up to the construction of mounted type storage vessels for storage of propane, that is only LPG bulk storage facilities at Paradip LPG import terminal at IOCL Paradip. This work does not meet the qualification requirement. Accordingly, this executed works would have not been considered for the qualified purpose. This is with regard to the, my lord, work order number 1. Now, regarding work order number 2, my lord, they have started it at page 176. But the, my lord, the findings, your lordship may come to page 178.
Yes.
Technical review.
Yes.
Second sentence. As per the submitted 4 numbers of work orders, bidder has executed 3 work orders on its rate contract basis. As per the tender requirement, bidder must have completed work on EPC, EPCC, LSTK basis. This work does not meet the qualification requirement. Accordingly, the executed works could not be considered for the purpose of qualification. My lord, I'll show, my lord, the work order itself shows it is EPC. That your worship will find at, my lord, page 85. For that, your worship may also peruse their finding on work order 3. Work order 3, my lord, it is about the middle, a little below, technical review. As per the scope of work, bidder's scope was limited up to double wall storage tank at refrigerated LPG terminal at Krishnapatnam Port, Andhra Pradesh. This work does not meet the qualification requirement. Accordingly, this exercise executed work could not be considered for the qualification purpose. So, my lord, these are the 3 findings. My lord, in respect of the, my lord, 3 work orders that, my lord, the petitioner has submitted along with the tender. Now, your lordship may kindly come to page 85. We'll primarily rely on this, my lord.
85. Page?
85, my lord. This is regarding my lord, work order 2. My lord, they have a clear finding that this is not EPC. And I am, my lord, primarily relying on this work order, my lord. This is work order 2, my lord. Purchase order. Your lordship will find, my lord. It has been given by CGB Private Limited. Your lordship comes to the chart below, serial number 003. Description, 2 numbers of refrigerated.
Where you are in page number 80?
85.
Yes.
Serial number 01003, your lordship will find in the chart, my lord.
No, 2 numbers, yes.
Description, 2
Yes.
numbers of refrigerated storage tank, EPC. This has clearly been stated in the my lord order, which has been completed successfully. Then your lordship will find, my lord, in the service details, completion of engineering supply, then my lord, completion of pre-commissioning activity, completion of electric instrumentation, everything has been completed.
And these 3 works which they have referred in their impugned email,
My lord.
all 3 are required or only 1 is required?
In fact, my lord, only 1 is required.
1 can be required.
My lord,
So if you are successful,
for technical, my lord, this is enough.
if you are successful in convincing or having a situation that the holding you to be holding the work number 2 is not would not qualify that to be bad in face of it, then you perhaps will
Yes, my
cross
lord.
the hurdle.
Yes. But
Okay,
then, my lord,
we'll come back at 2 o'clock. কোনটো আছিল টাইপে কাৰ আছিল আছে নেকি yes, what was it? Mr. Chaudhary, just a minute, will not take much time. What was it, Mr. Hussain?
Yeah, take instruction as per the law. If they submitted to.
Yes, we wanted to have the presence of Mr. Babar Pujari.
He's on election.
What instructions do you have?
One instruction was the district trustee.
Hmm.
Certain information was supplied from the district commissioner.
Yes.
That was awaited, Lordship.
Now, what is your prayer?
Some time may be granted for updated status of this.
Okay, heard Sri A.K. Hussain, learned counsel for the petition of error. Sri Satyajit Datta, learned counsel, appearing for the respondent number 1.
Respondent number 10. Lordship.
10.
Lordship.
10 has submitted, has prayed for some more instructions, some more time to get up-to-date instructions, full stop in this regard. He has placed reliance. Now he has placed on placed before this court a communication dated 21/20/26. Para, considering the above, comma, the matter is adjourned to be listed. We give a date
Yes.
on when? 13th?
13th February.
13th February?
Lordship.
Okay.
Oh, Lordship.
Yes. Yeah, Chaudhary.
It is your lordship. Now, I not see the issue that also consideration has come down to very, my lord, narrow boundary compass. So I'll confine my argument on those only, my lord. I'll
Please do.
make limited submissions.
Yes, yes.
May I take your lordship to please 85 again now?
85.
85.
Yes, we are in 85.
Just to, my lord, satisfy your lordship that, my lord, this is not, my lord, that's in a, reservoir tank, my lord, that this is an EPC work, my lord. I'll read that once again if your lordship.
Now we have seen this. Two numbers of refrigerated storage tanks within bracket APC.
Then your lordship may also kindly read what are the works done.
Hmm.
Completion of engineering, supply of major raw materials, supply of bottom insulation, installation of bottom institution, so and so, last 4 year lordship will see. Completion of pre-commissioning activity, completion of electrical and instrumentation, mechanical completion. Successful demonstrating of so and so. Now your lordship will kindly, my lord, come again to page 83.
Yes, please.
83, my lord, this is the certificate issued by the, my lord, the SSB, my lord. This is to certify and confirm that Mr. Surf Tanks and Structural Private Limited having their certificate. Then your lordship may come, my lord. Description of the works. Clause 1, my lord, subpara. Description to 15,000 LP refrigerated storage tank, EPC, for propane and butane along with other related facilities, engineering, mechanical, piping, electrical and instrumentation, pre-commissioning and commissioning assistance. And my lord, the completion certificate is at page 81. This is to certify and confirm that Mr. Shiv Energy Private Limited, having its registered as so and so, has issued a contract to Mr. Surf Tanks and Structures Private Limited, having their registered office at success and place, has carried out the below work. This I read, my lord. Second para. Design, engineering, procurement, construction, third-party inspection, obtaining all statutory approvals, mechanical completion, pre-commissioning, commissioning assistance of offshore gas processing plant. This is important, my lord. Offshore gas processing plant.
Where are you reading?
My lord, second paragraph at page 81. The description of the work that we have completed.
Yes.
The last line of the first paragraph says, my lord, has carried out the below given work. Design, engineering.
I never seen it.
My lord. So this is, my lord, onshore gas processing plant. Then your lordship may kindly come to page 37.
87.
37.
37.
37. 37 is the, my lord, NIT. Where the, my lord, requirement is there, which I have to fulfill, and I have fulfilled by this work. Page 37, this is, my lord, technical experience criteria.
Yes.
Now, I fulfill B, my lord. We fall under B. From the first sentence, I read, my lord, the bidder must have successfully completed at least one engineering, procurement, and construction EPC work. Engineering, procurement, construction, and commissioning of EPC. Then, my lord, the turnkey basis contract on its own. Then, my lord, your lordship may kindly skip and come to B.
Yes.
Any process unit in hydrocarbon sector, refineries or petrochemical or onshore gas and or oil processing facility or offshore gas and oil processing facility or fertilizer sector, fertilizer plant. And I fulfill this requirement. And, my lord, this is supported by the, my lord, work order as well as the order of completion. Completion certificate, your lordship will see that page 81. Now, if I may take your lordship to their affidavit in opposition at page 208. This, my lord, shows their non-application of mine or arbitrariness or malafide, my lord.
Page
208 in their affidavit in opposition. Now, my lord, at page 208, the starts at 207, my lord. The petitioner has placed on, may I read 4.8, my
No,
lord.
there are certain change in page numbers.
207, my lord.
No, there is some change in page numbers. When did they file? Is it by who? It is who's the?
They filed on 17th.
No, who is the deponent? Kajal Suikia.
Yes.
Kajal Suikia.
Yes.
Yes,
Okay, 20. It starts at 208.
Then, my lord, sorry, my lord, then may I?
Doesn't matter. You can say the. You can tell us the internal page.
Your worship kindly comes to para 4.8, my lord. These will be different. I'm sorry to trouble you.
No, it doesn't matter. Oh. Correspondence. Retender. Para?
4.8.
But it might be 216 in court's file. I'm just.
No, it's okay. We have found it out. 4.8.
8.
Yes, you're correct. 216. 4.8. Yes, please.
The petitioner has placed on record the following work orders and completion certificates in support of its technical
Yes,
and commercial
yes.
qualification pertaining to the respective entities.
Mm.
Then, my lord, your lordship may skip the IOCL part. The second, my lord, bullet point. SHB Energy, 4 work orders, 1 pertaining to supply of storage tank, and the other 3 pertaining to item rate contract for sundry mechanical works, including supply of manpower on man-days basis. This is 1 ground in 8, my lord. And thereafter, in paragraph 4.10. 4.10. How they are questioning the second work order, which we are relying on. Perusal of the related work orders placed on record by the petitioner itself at page 85 and 6 reveals that no such work as claimed in the completion certificate was ever assigned to the petitioner by Messrs. HHB. Instead, all the state work orders pertain to item rate contracts for the construction of storage tank, fire water tank, or mechanical works for laying pipelines, and do not encompass the comprehensive EPCC scope represented in the completion certificate. My lord, this I fail to understand, man. Because they now say it has been, my lord, item rate contracts. And also, my lord, they say that, my lord, it was only a supply of the, my lord, tank. Because entire, my lord, work that has been work order reflects, and the, my lord, completion certificate reflects, that has been totally ignored now. Now, if your lordship kindly turns to just a moment, I'm sorry. Then, my your lordship has now seen the EPC work, my lord, that has been allotted to us to complete it. Now they say, my lord, this is the EPC, this is the rate contract. Now the question is, my lord, all the works together, my lord, that supply, rate, and everything, my lord, that comprises of the EPC. EPC work does not, my lord, specify only one head. So, my lord, the certificates are very clear. Therefore, my lord, this, my lord.
What is EPC? What does EPC stands for?
EPC is, my lord.
Well, it's engineering, procurement, and construction.
Therefore, my lord, I fulfill the requirement of 10.4.1, 10.1.1B, and my lord, that could not have been rejected by me. Therefore, my lord, their assessment of the my lord entire process, that is my lord flawed. Perhaps my lord non-application of my, perhaps my lord there is some other reason that we do not know. But it is established that my lord this is arbitrary. They could not have rejected at least the work order 2, which my lord qualifies me. So far as my lord the technical part is concerned, my lord, we are not going to the commercial aspect because that is not required. That also, my lord, I can satisfy your worship. So this is in brief my submission, my lord, and I may be allowed to my lord come to whatever. I'm just my lord trying to be brief.
Yes, yes.
Okay.
Well, it's, at the outset, my lordship's question was as to whether you have been rejected only on the technical aspect. My learned friend says yes, but if I show the impugn order, both on technical as well as commercial, the bid is rejected. Now, what's the whole contention of my learned friend in this petition is that if we see the technical experience criteria under the NIT, read with my completion certificate under work order number 2, then I'm satisfying that criteria. I take it that way. The lordship was kind enough to ask them a question whether you are focusing on this EPC part, because their cases in that particular work order, I'll just show. The word mentioned is EPC, which is in consonance with the 10.1 criteria. This is their contention.
Correct.
Please read EPC here, EPC there. So therefore, since word EPC is finding a place in my work order, therefore I'm satisfying the criteria. I'll just show, but before that, let me just give you a bird's eye view as to what are these technicalities. Today, my lords, I'll show from the scope of work of this tender, because my respectable senior read what is the nature of the contract in the very first prelim, that is preamble of the tender law. The preamble of tender is that it's a complete LPG marketing plant, a complete unit.
Correct.
And we have said so in our counter affidavit as to what is this, what is the scope of this plant. It's a complete, it's like a complete building with on a turnkey basis. I just have to enter and I find everything in place. It's like a contract given to a contractor. I'm just giving you a plot of land.
Turnkey.
Turnkey basis.
Yes,
And that is the heart and soul.
Yes.
And that is why, my lords, the entire thing says in my NIT clearly, this is the scope of work. Please keep this in mind, because, my lords, any evaluation of the technical criteria cannot be aloof of the scope of work. My scope of work alone is consuming the entire page of the tender. There are at least, my lords, 50 items, if not more, that these are the things involved in this. That is, my lords, there. And that is why, my lords, in my technical criteria, I clearly specify that you should have done either on EPC basis, EPCC basis, my lords. EPCC is engineering, procurement, construction and commissioning, or on LSTK basis, lump sum turnkey basis. A contract, either of these three, on a single point basis, that you are the person who is doing everything for this plant, for any of the three. Let me just take your lordships to that technical criteria, because that is the heart and soul of the dispute before lordships.
Yes.
And that your lordships will find at page 37.
10.1.
10.1.
Yes.
Before that, may I show your lordships the scope of work?
Please do.
34. Introduction, lordships, my senior was pleased to read. I'll show the scope of work. Brief scope of work.
Yes.
Bidder, upon being selected as successful bidder, shall execute the work on lump sum turnkey basis LSTK with single point responsibility. The scope of work includes consistency checks, residual process, engineering, detailed design engineering, including HAZOP, this, my lords. This goes on. And my lords, please see the capital letters in between this paragraph in the middle. Balance of plant works for LPG marketing terminal, process plant, preparation of operation manuals and all that. So it's basically, my lords, Novali guide is lordships know. So there's a LPG terminal, complete marketing terminal. And I am, my lords, may I just show as to what is this? In fact, Lord. This is a bird's eye view, Lord, as to what. Oh, please. I'll just.
Mr. Chaudhary, you can have a copy?
Yeah. These are, my lords, broad components, not even, my lords, small. I have not shown. I've just broadly depicted as to this is what is the scope of work we are looking for. This is an example that this is what is required. Now, this is a complete unit.
No, this diagram of yours is pertaining to what?
It's a processing unit.
No, pertaining to what?
Well, what they claim is that we are satisfying the work order with respect to the processing unit.
Yes.
Of an onshore gas processing plant. That is work order number 2. That is the case.
Okay.
So here
you have placed this
as a processing.
To counter their argument, perhaps that they have not done this kind of work.
I'll show lots because their own name suggests as to what do they do. What is their primary business? Their primary business is to provide tanks. Their name is Sharp Tanks. They have never been into this kind of work. To give, my lords, a complete plant or unit on a turnkey basis. They have never, my lords, not even distantly. And my lords, as a matter of fact, when it came to getting the tanks for plant, etc., we have already given them a contract because the scope of work was limited. So they are already working for us.
Are you disputing the certificate by SHV?
I will show that, my lord, certificate. That is very interesting. That certificate is, my lords, dated 25th of August 2025. 20th August. Yes. Certain dates, my lords, make it very interesting.
Just a minute.
Yes,
completion certificate is dated?
I'll just. Page 81.
Yes.
It is 20th August.
20
August 2025.
Yes.
The tender is floated admittedly in July 2025.
Yes.
Now, please see, my lords, when was this work, which is shown to have been completed, where this completion certificate was completed? 18 December 2022.
December
2022.
Yes.
So work was completed in 18 December 2022. We floated a tender in July 2025. In August, you come up with this completion certificate. The words are like tailor-made so that you can place in some document somewhere. And that is why, my lords, in 10.4.1 of the NIT, we have consciously said that what documents we are asking you to evaluate your technical bid. Completion certificate is absolutely secondary, my lord. We want work order. What work order was given to you? Because completion certificate, my lords, is given for a particular work done. And it cannot be out of the purview of the work order. If it is out of the purview of the original work order, then you have to show some amendment. That my work, scope of work was enhanced.
Work order is not here.
It's here, my lords, it shows something to the contrary. What is written in this completion certificate is not there in the work order.
Let's see the work order.
Please see that.
Work order is at 83.
My lords, may I just show? This completion certificate itself says what was the scope of the work. My lords, may bear with me.
Yes, yes.
Page 81 again.
Yes.
They are relying upon para 2 of this page 81.
Correct.
We have done all this. And they are trying to show that this is, my lords, an onshore gas processing plant.
Yes.
That they have done. So, my lords, I take it this way. What they are trying to project before lordships is if we see, my lords, 10.1, second criteria option,
Yes.
that is, you have done a contract for establishing a complete onshore processing plant.
Yes.
That is what I've understood their argument is.
Yes.
And they want to read that criteria with the second para of this completion, saying that, see, you meet the two words, two phrases, and we are completing. But please see, my lords, in this very completion certificate, the second last line, the details of the executed work, my lord,
Yes. Annexure 1 and 2.
yeah, the details of the executed work are enclosed here, annexure 1 and 2. Please see annexure 1 and 2, my lord. Page 82.
Yes.
What they have done. And my lords, serial number 1, this is the purchase order number, etc. The description of work is on the right hand side.
Yes.
Right hand side column. Description, may I read?
Yes, yes, please.
2 into 15,000 empty refrigerated storage tanks, EPC, for propane and butane along with other related facilities. Engineering, mechanical, piping, so and so, and commissioning assistance. Then second, 2 numbers, 100 empty mounted storage vessels for propane and butane. The work includes engineering, civil supply, so and so, and so and so. And 2 numbers, so and so, fire water tanks. Then mechanical works for cross-country pipeline and jetty area. Then third is terminal mechanical works. Now, my lords, what they want to read into it is that if we have done, my lords, it's like, I again take the same example. I am giving a tender, floating a tender for a complete building. Now, in that complete building, there may be a requirement of overhead water tanks. Either I say that you just provide me 2 tanks, rest of the things I'll see, only with respect to the 2 tanks. Or I say that you establish these 2 tanks for this entire building and on your entire responsibility. Water should flow in my tap. What they are trying to say is, since we have done these tanks, please assume this to be a work of the entire building. This is what this description clearly provides. You have only provided storage tanks. Your forte is tanks. Only a component of this plant. And that is why, my lords, that pictorial diagram which I have shown, the lordships will see on the right hand side bottom. Tanks are there. They are a part of the plant.
But what about annexure 2 at the next page?
Yes, yes, my lord. Annexure 2 also, the same problem. Now, these are, my lords, different purchase orders. None of them relate to any of the 3 options in the criteria given. Again, the same problem.
No,
It's, my lords, annexure 1 and 2 are same.
Yes.
Annexure 1 is concise of
Yes.
the annexure 2.
True, yes.
Description of work is same in annexure 2 also. So annexure 1 basically, my lords, is we can rely upon annexure 1.
Yes, correct.
Nowhere, my lord, even distantly, it mentions as to how you have done either of the 3 criteria. The 3 criteria are, number 1, either you have done a complete contract for an LPG marketing terminal. Number 2, option, if you have done a processing unit. And number 3, if you have done a complete power plant. So we are talking about a complete system over here.
Yes.
Not only tanks. Process unit is defined under, my lords, petroleum and natural gas regulations. I may just show that. That is important. Not tank, my lord, not storage. That is. What? My lords, in fact, these are the submissions which I prepared on the last date of hearing. But since the affidavit is there, let me just read this because they are in consonance. But in this submissions, I have placed the definition of the processing unit. Baby. Para 7. Para 7. So this is the definition of processing unit. Process unit means a unit having integrated sequence of operation, physical and chemical, and may involve preparation, separation, purification, or change in state, energy content, or composition. So, but I think, but they want to thrust upon their submission that please assume that this is, even distantly, storage tanks cannot fall within this criteria. And now your take lordships to para 10.1 of the tender law, page 37. This is the technical experience criteria again.
Yes.
The bidder must have successfully completed at least one engineering, procurement and construction / engineering, procurement, construction and commissioning / lump sum turnkey basis contract. So this contract word is qualifying each of the three options, either EPC contract, EPCC contract, or LSTK contract. On this basis, on its own, with single point responsibility involving project management, design or residual design and detail engineering, procurement, construction, pre-commissioning, commissioning assistance during last payment for any one of the following. Number 1, an LPG marketing terminal or LPG dispatch terminal involving LPG gantry and associated off-site utilities, which may or may not include LPG bulk storage facilities. So storage is not even a mandatory option. You are saying that we have done storage. It's not even it's just an option over here. What we want is turnkey. LPG comes, it is distributed. It's come.
No, Mr. Chaudhary says he is fulfilling B.
Yes.
So you can concentrate
Coming to
on
B, my lord. Coming to B.
A and C we can for the time being ignore.
But my lords, I am saying please see my tender as a whole because the objective is absolutely clear. I don't know why.
No, that is okay. But if he fulfills one of the conditions,
Yes,
yes,
sir.
true.
Absolutely.
He says he fulfills B.
B.
You make out a case that he doesn't fulfill B.
Yes, ma'am. The B is any process unit in hydrocarbon sector, refineries or petrochemical or onshore gas and oil processing facility or offshore gas and or fertilizer sector. Fertilizer is not his case, my lord. His case is I have done a process unit, but that is not, my lord, the work orders or even the completion certificate does not say that you have done a process unit. You have to see the description. That is not, storage tanks cannot become a process unit. Now, let's please see.
No, if you are not on the completion certificate, what about the description of the work at page 81 again?
Yes. It does not say anywhere processing unit.
No. See, design.
Yes.
Second paragraph.
Yes.
Design, engineering, procurement, construction, third-party inspection, obtaining all statutory approvals, mechanical completion, pre-commissioning, commissioning assistance of onshore gas processing plant for Tuticon project or HAV.
Malad sir, reading the page 81, second para.
Yes, that is it.
Malad, please appreciate. First of all, this is a completion certificate. My submission is procured as tailor-made, just to mislead the honorable court. Because, my lords,
Have you said so?
Yes, my lords, I have said so in my counter that
Let us see.
This is procured.
Let us see.
Yes.
Now see, a certificate has to be procured. Otherwise, how do you? So
procured in the sense, my lord,
there has to be some objective satisfaction. You can either say the contents of the certificate is disputed, the certificate is a forged one, certificate is unauthorized, all those are available to you.
No,
Now,
I've
if you have not said,
I've not said it's a forged certificate.
no, if you are doubting on the contents of the certificate, the correctness of the certificate,
Lord.
correctness, then you have to make out a specific case
My
in
lord,
your
I have
affidavit.
said, in this sense,
Hmm.
that your work order is the primary document which I have to see. I will show the clause.
Correct.
That what documents I will evaluate to see your fulfillment of technical evaluation criteria.
Yes.
Work order is my main order, main document. Because completion certificate comes later. I will have to compare both of them. Because otherwise, my lords, what will happen?
Now, have you stated that they have only because of the fact that they have not given the work order and only relying upon a completion certificate, it will not suffice the requirement?
I've said so.
Where have you said?
In my impugn order also I've said.
No, where have you said?
Yes, my lord. Can I show from the impugn order? Or?
Yes.
Yes.
That will be better.
Yes. Page, annexure 16, page 171. It starts not there.
Yes.
I'll straight away take a lordships to work order number 2.
Page?
Just a minute. Work order number 2 is dealt with at page 176.
Yes.
Client so-and-so. In fact, you have submitted multiple work orders issued by the said client with details as follows. Now, let's please see the note. Just a minute, I just. Yes. Let me just see page 178. Technical review.
Yes.
And before that, my lord, note. This work order also was an item rate contract with no element of setting up and commissioning of a complete plant on turnkey basis. Technical review, as per the submitted 4 number of work orders, bidder has executed 3 works orders on item rate contract basis. As per the tender requirement, bidder must have completed work on so-and-so basis. This work does not meet qualification requirement. Accordingly, this executed work could not be considered for the qualification purpose. Bidder has submitted in his bid these work order to qualify as onshore gas processing plant, whereas based on submitted purchase orders, the scope is related to storage tanks, associated works which does not meet similar work requirements of the NIT. And please have now, my lords, clause 10.4.1 for a moment at page 43. Page 43. What documentation we needed to force this evaluation?
Yes.
But documentation, the second row I'm reading for technical and commercial experience criteria.
Yes, yes.
That is 10.4.1a I'm reading. For technical experience criteria, the bidder shall furnish documentary proof in the form of copy of work orders or contract agreements or relevant pages of the contract documents mentioning the scope of work along with completion certificates issued by the owner and so or any other certificate issued by the owner that the work is commissioned fulfilling the technical experience criteria. So our objective, if I may submit now, for assessing as to what work you have done, the document which was to be submitted was the work order. It cannot be anything else, my lord. Completion certificate is to be seen only to see that the work order scope of work has been done by you, not to expand the scope, which is not there in the original work order. Otherwise, my lords, it will wreak havoc. Why? You have a very small work order in which you have done, my lords, whatever. But then completion certificate somehow you are able to get with words written over it. I'm not saying forged. but maybe some words which are superfluous of the original thing which you have done, then my lords, it will be like misleading. And that is what exactly we have said, that see, completion certificate is only to see. But work order, my lords, is the right criteria, which is not able to show. And that is why, my lords, their entire case is hinging upon this completion certificate. In my respectful submission, my lord,
Yes.
this completion certificate, with the conspicuous date of its being obtained, is only to somehow create a farce of fulfilling the criteria. And that is why, my lords, there is a catch in the completion certificate also. Why I am saying so, my lords? Forget, my lords, assumingly everything against me. Assumingly, the completion certificate can be taken as the final and only document to assess what work he has done. Assumingly, my lord. Then also, my lords, the person who has issued this completion certificate was, my lords, deliberate of the
We have
conscious.
seen that it is for the
Why?
purpose of his qualification. That
Why,
was
my
seen
lords? Why? This person is writing what in the completion? The lordships have seen the second para. Second para, if we read in isolation, my lord, it definitely gives some impression that he has done a process plant, process unit. Please have that with me again. And there is what, where, my lords, the malafide of the petitioner is coming out. Please see, my lord. How may I read, my lord,
Yes.
second para again?
Yes, yes.
So he is reading design, engineering, procurement, construction, third-party inspection, obtaining all statutory approvals, so-and-so, commission, so-and-so, assistant or assistance of onshore gas processing plant for Tuticorin, Tamil Nadu, against single tender inquiry of so-and-so project. This is written, my lord. If we read this in isolation, some impression is given. But the issuing person is conscious of the fact that this will not be complete. This representation will not be complete unless I specify the details of the executed work is as per the annexure 1 and 2. So it cannot be read in isolation as per this completion certificate also, Lord. Now, I will just show from the horse's mouth as to what is the purchase order, page 85.
Yes.
This is the purchase order, Lord. Please see the scope of work. Description of the item. 2 numbers of refrigerated storage tanks, my lord. Page 85, I am reading. 003, serial number 003, my lord says.
Yes.
So, my lords will see description of the thing which is providing. My lords has 2 numbers of refrigerated storage tank on EPC basis. Now, my lords, I say I have already, my lords, submitted that EPC can be of a simple computer also. That I'm not bothered. You just fix the computer on my desk. I don't care. It should be, I should push the button and it should be working. And EPC can be of the entire room, that I want the entire conference room. What he's saying, I have fixed the computer. So that is why I'm satisfying the requirement of entire conference room. That is not. But
These are planned for storage tanks separate from.
And my lords, when he applied for the tenders of storage tanks, he has already been granted those contracts. He is doing, though there are problems with that also, but I'm not going to do that. I have letters to show that even in the storage tanks limited, and now, my lords, I'll just, as a last limb of my submission, my lord, he has not even fulfilled the commercial criteria. What he is trying to portray, and he tried to portray for commercial bids, that please combine my various purchase orders and see the combined value of. That is not our requirement. Our requirement for commercial is that number one, you should satisfy the technical criteria. And number two, in that technical criteria, if you have done any processing unit, then the value of that processing unit must be more than 141 crores. Because, my lord, this project on an estimate is going to be around 300, yeah, an estimate. So we want a person who can do it. And that is why lordships call for the records of the process. I have the selected bidders profile. I'll show, my lord. One has both of them done in a single plant. And this is available on the portal to them also, which they are not showing. For a single plant which they have done around, one has done 280 crores, 290 crores. The other is also, my lord, 270 crores. Everything on a turnkey basis. And your lordship, I'll show from his purchase order, he is being paid on item wise. He is being paid for laying out the pipeline only, not a plant, my lord. How can, by any, my lord, stretch of imagination, we could have not, rather, my lords, might done it, my petitioner, for the sake of his satisfaction or whatever, my lords, has wasted so much of time, my lords, of my officers in, my lords, this evaluation, re-evaluation, this and that. Unnecessarily, my lords. It's a fit case, my lords, for some exemplary cause. That's one thing. This is the third petition. And each and every time, this is not the first time that we responded to his representation. Way back on 26/12, we wrote to him that, see, this is, your work order is not matching with your completion certificate. That is also on record. But he is not stopping. And that is why, my lords, please bear with me, my lords. We, as a prudent PSU, my lord, so that a particular bidder does not have any say saying that we extended the price opening bid, my lords, maybe over a month. My lords. This is my submission, my lord. On the face of it, this petition is an abuse of process of law. Obliging.
Yes, Mr. Chaudhary.
Only one thing, my lord. There are a number of judgments, my lords. I can take your lordship's time, but your lordships are already an authority.
No, not at all. You can cite some judgments if you want.
Well,
Not many.
Yes, my lord.
The latest one or two you can say.
Yes, my lord. The same, my lord's criteria that the technical thing is an forte of owner, this and that. Only on that.
NRL may submit, my lord, if they want to submit. Then, my lord,
Is NRL?
I'm NRL. Take.
Question number 3, I think mine is running from APS for question number 3.
I think they'll have the same stand.
They're in my boat only.
But we have the consultant, my lord, we have experience, we have the company from France, my lord. And I have details of the company.
Your R, Mr. Roy for R?
R3, my lord.
Consultant.
Consultant.
It is through you which
Yes.
the procurement has been sought to be done.
And lordship, we are actually head office at France, my lord. And our office in India is in Chennai and Delhi. And we have been engaged for the expansion project, my lord, from 3 MMT to 9 MMT, my lord. Project is a huge work, my lord. And plus, my lord, this is so highly technical, my lord, that care has to be taken, my lord, so that tender, the contract does not go to a person who is not capable of doing the job. And I can give my my lord, we have 17,000 employees to the world.
We are not bothered to consult with that.
My lord.
We are concerned with the decision-making
Yes,
process.
taking a concise decision.
How many thousands of persons who are shown?
Of the work order they have produced, my lord. And your lordship has already seen that, my lord.
Well, I'm just bothering your lordship with these two judges.
Yes, please, give
One is
name, please.
Well, its name is. One is our own, well, it's Guwahati High Court. It's technical. So this is Technip Energies India Limited versus Union of India. And I'll just.
Do you have the citation?
Citations, this is what the court, this is writ appeal 258.
Of our court? You
Yes,
cite
yes.
from Supreme Court?
Supreme Court is also, I'll just show. So writ appeal 250, but this is with respect to NRL project.
Okay, doesn't matter, we need the
Yes.
principles of law.
Yes, yes.
But still then, writ appeal?
Writ appeal 258 of 2023.
Name, Technip.
Technip versus Union of India. Para 12. And then para 52 of this Tata Motors, three judges bench of Honorable Supreme Court. Para 52 reads, this is a citation, I'll just give the judgment. This is civil appeal number 3897 of 2023.
3897/23.
Of Tata Motors versus Best, the Brihan Mumbai Electric Supply and
Yes,
Transport. Yes. Para 52 of this Honorable Supreme Court judgment says, ordinarily, a rate court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tenderer unless something very gross or palpable is pointed out. The court ordinarily should not interfere in matters relating to tender or contract. To set at naught the entire tender process at the stage when the contract is well underway would not be in public interest. Initiating a fresh tender process at this stage may consume a lot of time and also loss to the public actor. And so on. These are the two.
Okay.
My lord, I'm obliged, my lord.
Yes, yes, Mr.
My lord, before leading with the, my lord, meeting the contentions of my learned friend, my lord, he has made a, my lord, passing remark about a contract being executed by the petitioner in RRS, where they are apparently, my lord.
No, we are not influenced by
my lord,
those.
He has made this submission.
We are not
my lord,
influenced by
that is a
those.
litigation, my lord.
We are not influenced by those.
That submission he has made, my lord. That's why I am pointing out.
We are not influenced by those.
So that may be the reason, my lord, why this arbitrariness, why this our exercise has been taken. Now, my lord, the impugned order has to be tested on the basis of the conditions of the NIT. And my lord, whatever reasons have been given in the impugned order rejecting my NIT, there, my lord, the reasons stated therein is only relevant, not, my lord, what is stated in the affidavit in opposition, or, my lord, what my learned friend has submitted beyond this, my lord, order. Now, my lord, my learned friend has drawn to the attention of your lordship to the, my lord, the work order, because, my lord, I read only the preamble where it says, my lord, it is if your lordship kindly comes to the NIT.
33.
Is 34, my lord. I
Yes.
read only, my lord, balance of the planned works, because,
Yes.
my lord, I was, my lord, the harping of the word balance. It is a half-done work,
Mm.
and that has been sought to be completed by this. Then, my lord, my learned friend wanted to project, my lord, what is the work I am supposed to be done?
Mm.
Now, my lord, what is the work if allotted has to be done? That is another aspect, and what is the qualification he required is another aspect. He has given an example, my lord. I'll give an example. Your requirement says that you have to build, you have the experience of building a 2-storied house, but we are building a 7-storied house. So 7-storied house, whether I have built or not, that is not the issue. The issue is, my lord, whether I fulfill the criteria of, my lord, the requirements, which is there for building a 2-storied construction. Therefore, my lord, going to the scope of the work cannot be related to the, my lord, the requirement.
No, Mr. Chaudhary, rest assured, we will examine the decision-making process qua the eligibility criteria.
True, my lord.
We are not, will not linking, it's up to their judgment. What do you want to be, what criteria should be made as qualifying criteria?
Yes, my lord.
If
And
they have
my-
given that you can be qualified if you have built a 2-stories house, we'll only see whether you have built a 2-stories house.
Exactly, my lord.
That you rest assured.
My lord.
We were only checking, we are only examining that whether the work which you have relied upon would meet the eligibility criteria.
Yes, my lord.
That only
I'll limit my submission on that, my lord.
yes.
Now, my lord, they say that, my lord, the requirement of, my lord, the EPC and offshore, these are the two words, my lord, repeatedly used. If your lordship comes to the, my lord, NIT conditions, what are the requirement? Whether, my lord, that requirement is fulfilled by the work orders and the completion certificate. Now he says, my lord, we need not go into the completion certificate, the work order itself is enough. My lord, in the NIT, they say, my lord, they have to consider both. If your lordship kindly comes to, my lord, the page 43.
Yes, please.
They cannot deviate from the requirement they have given, my lord, what is specific in the, my lord, NIT. Page 43, clause 10.4a. For technical and commercial experience criteria, the bidder shall furnish documentary proof in the form of copy of work orders / contract agreements / relevant pages of contract documents mentioning the scope of the work along with the completion certificate. Therefore, my lord, they need to consider both. Now they cannot say we will only go, we will look into the work order and not what the, my lord, completion certificate say. And your lordship will see this document. My lord, the work order number 2, which you have produced, that is of 2020. My lord, an indication has been made, my lord, the certificate has been, completion certificate has been procured. Meaning thereby, my lord, that ordinarily or ought not to have been, my lord, issued, but we have convinced them to issue it. In 2020, how would you know that they will be advertising, giving an LIT and this will be requirement? This is too far-fetched, my lord. That is of 2020. And 2020, we have fulfilled that EPC requirement. If your lordship, my lord, kindly comes to page 85, your lordship will be clear about that, my lord. Page 85, my lord, I take your lordship indulgence to read that again, my lord. The purchase order is dated, my lord, 11/3/2020. And, my lord, the work order itself says, my lord, this is on EPC basis. And although, my lord, the description says that 2 numbers of refrigerated storage tanks, my lord, the storage tank does not come alone, my lord. What are the other things to be followed? That has been, my lord, explained in the, my lord, service details. Therefore, my lord, it does not lie in their mouth to say that, my lord, this is not an EPC. And this is only, my lord, raising a storage tank. This is one argument, my lord, my learned friend has been making, which is not supported by this document, the, my lord, completion certificate.
So,
as
Mr.
well as the-
Mr. Chaudhary,
My lord.
we can go one step forward. EPC, EPPC, EPCC or LSTK are 4 or 3 of the expressions used.
Alternatively.
Alternatively, 3. Now, you must have done a structural, the storage tank as an EPC. That is not the deciding factor. EPC is not the deciding factor.
Yeah.
Deciding factor is the qualifying criteria.
My lord.
What are you required to have as a qualification?
My lord.
Now, you have done something on EPC. What have you done on the EPC? We may agree with you that it's on EPC basis because the certificate says so.
Yes.
You're not doubting the contents of the certificate. You have all a completion certificate also. We may answer your thing, just thinking aloud, that the documentation part, 10.4, which you have just read at page 43. See, for the technical and commercial, if you come to page 43, 10.4, for technical experience criteria, bidder shall furnish documentary proof in the form of so-and-so, so-and-so, and so-and-so, along with completion certificate. The requirement, the vital aspect is the first part, to show what you have done. No, we are not saying that completion certificate is not required. Completion certificate is to only say that you have done it successfully. Completion certificate may not give a total indication of what you have done. Therefore, they have not used one expression. They have used copy of the work orders, / contract agreements, / relevant pages of the contract document. That means they want to be very sure of what is the work you have done, or you are relying upon. You say that I'm experienced with this kind of work. You are equipped with a completion certificate. We are not saying that we are ignoring or they are not obliged to see the certificate, but that completion certificate would have to give a definite conclusion, we have to bring them to a definite conclusion that you are qualified under this aspect. Now, let us see again that completion certificate.
Completion certificate, your worship will give-
Page 81, I think.
81.
81.
This is the certified and confirmed Mr. Sheet.
And you can, second paragraph will help you. Let us see the design, engineering, procurement, construction, third-party inspection, obtaining all statutory approval, mechanical so-and-so assistance of offshore gas processing of so-and-so against single tender so-and-so. The documents so-and-so. The details of the executed works are enclosed as annexure 1 and 2. And there are two annexures,
Yes.
page 82 and page 83.
My lord.
82 is the description of the works.
Right.
Two numbers of refrigerated storage tank, again 2 numbers of mounted storage vessels, 2 numbers of fire water tanks, mechanical work, and the second one at page 83, it is a further description that these storage tanks were done on an EPC mode. The first one.
My lord. So this fulfills the requirement.
Now this we have to match with B, which you say you are fulfilling B. Let us see B
81, my lord.
at page 37.
B, my lord.
Yes.
Any process unit in hydrocarbon sector, refineries or petrochemicals or onshore gas. I'm stressing all that, my lord.
Yes.
Oil processing facility or offshore gas or oil processing facility or particular sector. Onshore. That we have done, my lord.
Any process unit. Is any process unit defined anywhere?
I've given the definition.
In the NIT, my lord.
It's defined in the RPN. Regulation.
Page.
Yes, in my submissions, my lord, I've reproduced.
That's it.
There are 7 of the commissions, my lord. This is the same.
That should be in the NIT. my lord.
No. Statutory, my lord. This is statutory and process unit by the name itself shows that there has to be a process involved of converting something into something. That is what.
Where do you get, Mr. McGold?
Para 7
Of your affidavit?
of my submissions, my lord, which are there. These are statutory, my lords. These are.
A process unit, oh yes.
Yes, yes. But it is a unit, process unit means a unit having integrated sequence of operation, physical and chemical, and may involve preparation, separation, purification, or change in state, energy content, or composition. But I don't need to.
This is not there in the NIT. This is not there in the NIT.
And my lords, I'm so sorry, my lord. My friend,
No, we'll come back to you. We'll just.
All right.
We'll just let him complete first.
Yes.
Yes, Mr. Just complete.
My lord, may I trouble your lordship with the, my lord, clause A at paragraph 43 again, my lord.
43. Yes,
That
please.
will be very vital, man.
Hmm.
For technical expense criteria, the bidder shall furnish documentary proof in the form of copy of work orders, contract agreements, relevant pages of the contract documents mentioning the scope of the work along with the completion certificate issued by the owner consultant drawing documents, certificates. The commercial expense certificate, my lord, that might be relevant. Now, my lord, if your lordship finally comes to page 214 or 218 in the affidavit in opposition, what they say, man?
Paragraph.
That will be my 4.21, man.
4.21. It's the 223.
May I read that?
Yes.
The petitioner is also trying to argue and attempting to contend without producing any supporting documentation that the completion certificate should be read and considered in isolation from the corresponding work order. This is not we are doing, my lord. We are relying on both the work order as well as the, my lord, completion certificate. Well, apparently, such argument cannot be accepted inasmuch as the work order constitutes the primary document under the tender, and the scope and validity of the completion certificate can only be properly assessed in conjunction with the parent work order. That is what I did, my lord. That you have to read both of them in conjunction. Further, clause 10.4.1 of the NIT at page 43 expressly provides that the scope of the work executed by the bidder shall be evaluated based on work order contract issued by the concerned employer. Now, my lord, by this, they want to, my lord, give a go-by to the, my lord, completion certificate. They want to, my lord, confine only to the work order. The NIT conditions, my lord, require that both have to be considered. And they also say, my lord, both of them to be considered. But then, now they say that only, my lord, work order is to be considered. And, my lord, what is the reason? And, my lord, page 43, my lord, there, my lord, they say that the clause A that your lordship reads, my lord.
Yes.
And the certificate also. Other certificates issued by the owner's consultant certifying that the board is commissioned, fulfilling the technical experience criteria that we have produced by producing the, my lord, the completion certificate. They want to keep it away. And, my lord, what is the reasoning given, my lord? Whether, my lord, that reasoning given in the impugn order can, now it cannot be improved by their affidavit. Whether, my lord, that is in terms of the clauses of the NIT, that is the issue, my lord, that your lordship has determined, my lord. And what is the reason given? Your lordship will once again read, my lord, in the impugn order. Because they are trying to improve on that. Work order number 2, they say at page 178, my lord. And yes, 177, they say, my lord, these are item rate contracts. This is one of the reason of rejection, page 177. The aforesaid work orders clearly shows that the same were item rate contracts and were nowhere even remotely similar to a lump sum turnkey basis project. Now, my lord, I ask.
You're reading where?
Page 177, my lord.
No, not 170, not can be
177.
Or yes, yes. Note.
Note, my lord. The aforesaid work order clearly shows that the same were item rate contracts and were nowhere even remotely similar to some lump sum turnkey basis project. Now, my lord, I must ask myself this question, my lord. Where is the prohibition that you cannot have these item rate contracts, my lord, in a my lord EPC order? There is no prohibition in the NIT. Now you cannot take this as a point for rejection of my lord tender, and thereafter your lordship will find, my lord, at page 178, the review, my lord. This is the reason why I have been held to be technically disqualified. As per submitted 4 numbers of work orders, bidder has executed 3 work orders.
Where are you reading?
It's 178.
178.
Technical review.
Yes.
This is the, my lord, primary ground on which, my lord, the petitioner will be held to be not qualified.
Yes.
As per the submitted 4 number of work orders, bidder has executed 3 work orders on item rate contract basis. There is no prohibition, my lord. Let my lord reference show that there is a prohibition in the, my lord, conditions of the NIT. As per the tender requirement, bidder must have completed work on EPC, EPCC, LSTK basis. This work does not meet the qualification requirement. Accordingly, this executed work could not be considered for the qualification purpose. My lord, with my limited understanding of English, my lord, what I understand is that, my lord, because there are rate contracts, this is not an EPC, these are not qualified. Unless, my lord, they are able to show that there is a prohibition that rate contracts, if the work order constitutes, rate contracts also is a part of it. It is prohibited. They have to show that, my lord, to justify their action.
Yes.
Then purchase and B, they say, my lord, bidder has submitted in his bid this work order to qualify as onshore gas processing plant. Whereas based on submitted purchase orders, this scope is related to storage tanks and associated works which does not meet the similar works requirement of the NIT. So primarily, my lord, they want to say that there are rate contracts included in the work order. Therefore, you do not qualify. Unless so, my lord, there is nothing stated in the NIT that regarding this, my lord, rate contract. If you can show that, my lord, there is prohibition, my lord, I am out of court. Therefore, my lord, my submission is that, my lord, either there is, my lord, non-application of mine. In fact, my lord, there is application of mine and they are trying to find out, my lord, how arbitrarily I can be ousted from the competition. I may not give the contract, my lord. What is my prayer is that qualify me as technical. Thereafter, in price bid, I may be there, I may not be there. But why are you ousting me now? When I have, my lord, fulfilled the requirement, and now the requirement cannot be, my lord, now they can explain it in their affidavit or in the, my lord, in the impugn order and come to a different finding, which is contrary to what is there in the, my lord, NIT, the qualification criteria. This is my submission, my lord. This is not only arbitrary, my lord, the malafide is now clear. I have also, my lord, Ellis malafide in my petition, my lord. Malafide I have stated, my lord, in page 23. Now, my lord, the malafide is clear, my lord, the cap is out of the bag now. My lord, I'll rely on some judgments, my lord. In fact, your lord.
Regarding what?
My lord.
Regarding
that, my lord, they cannot be arbitrary.
You
And
can,
they cannot be, my lord, hyper-technical.
yes.
This is hyper-technical, my lord, that is what is there.
Which one?
My lord, there are two judgments of your lordship, my lord. Other Supreme Court.
No, please, Supreme Court.
Please, and my lord, I have prepared a note if your lordship permits me. And
Please.
On Supreme Court decision only, my lord. Because the earlier decisions, my lord, Tata failure and all, my lord, we did not, my lord, bring to your lordship's notice. One note and, my lord, two decisions of your lordship earlier in, my lord, similar cases. And one Supreme Court decision. Now, I will reiterate, my lord, this is not a fresh work. This is a work half done by other contractors, re-advertised, NIT issued, and, my lord, it is a, my lord, the remaining part we have to complete.
Well, I have to give a very important clarification.
Just 5 minutes, I'll say.
Yes.
For his agenda is over. Just any clarification, please.
Yes, but please have the brief scope of work again. Because my senior is saying that it's a half-done work by somebody else.
Balance.
I have to do balance. But the fact of the matter is, if we read the scope of work, why it is called balance? Because in the same plant, same LPG marketing terminal,
yes,
the storage contract is already given to them. So the balance of the entire plant, sans storage, is what we have advertised.
Where do you get this?
Because, my lords, the entire scope of work nowhere mentions storage. It says balance of works means this.
Yes.
And storage was given to him in the same terminal because he was qualified. So, my lord, this argument goes in my favor. Number one, my lord. And therefore, my lord, and secondly, but the persons who are selected, I just want to, my lord, please see, this is on the portal. There, it is not their case that the other persons are wrongly selected. It is all on the portal.
No, you don't want to be. He is not even raised that point.
Yes.
He is only challenging his disqualification.
That is good.
This may not be.
Please see what they have done, my lords. This is what we want. The first person which I am showing is a contract of
Mr.
2010.
Please, it is not required.
All
you
right.
have to justify your decision qua his challenge.
Very well.
He's not challenging why the others have been qualified.
Very well. Very well. That's
Okay.
One thing,
No, no, it's over. No, I think.
No, what I thought I will,
Yes.
I feel that, my lord, one point your worship may perhaps, my lord, consider that, the matter was deferred till, for hearing till today. And they said, my lord, it will be opened on.
tomorrow.
The second.
Now, what is the order passed?
That has to be extended.
Now, what is the order passed? They are saying will not do.
Well, it's till tomorrow we held our hands just
Hmm.
for the sake of, the petition can get a disposal on merits.
They
What
filed
was the order?
affidavit on 17th, my lord, Saturday, and we did not get time to file the reply, my lord. We did not pray that, my lord, we should be given time to file the reply because your worship was inclined to, my lord.
Deferred until further orders. As a deferred till. No, that is his submission. It is
Yes.
deferred till further orders, but don't worry, the judgment would come immediately. With today it may not be possible. But probably tomorrow.
Well, then what I will do it, I'll advise my client to have it day after tomorrow. Price bid.
It's your prerogative.
No, Mallards, because
You
once
go by the orders of the court.
No, Mallards, the problem is this. In the portal, because the portal is not in our hand, we have to give some date.
You may not, there may not be a worry on that count. We'll try to have the judgment tomorrow itself. You do whatever is required from your part.
Very well. Very well.
Let it defer for week.
Already deferred, sir. It's a very important project.
Heard 3 M.K. Chaudhary, that is Senior Counsel, assisted by Sri S. Khond for the petitioner. Please give your name. Also heard Sri Egarg.
Egarg. With
For the respondent number?
For respondent number 2, my lord.
One, you are for one. This is for one. He's there, I think he's there. We can record his name. He was there. 3 SS5 for SFCC for one. You're for two. So 2 for Egarg and 3 J. Roy Senior Counsel, assisted by Visa for respondent number 3. Hearing is concluded. Reserved for judgment.
But this is one last leaf which I am submitting, a difference between process unit and storage tanks. Copy. In furtherance of that diagram which I have, that's all. And my lords, with Mr. U. Sharma, my lords, he has come with me from Delhi.
Okay.
He has assisted me well. So deeply obliged, my lords, to for this patient.
Okay. और वैसे नहीं मैटर हम कल कोई नहीं तो जजमेंट तो डिपो लगे देख कोई डिपो लगे
Too deeply. It was a pleasure, my lord.
Yes, instructions.
Madam, there is some difficulty, madam, it's a portal, madam. Once the date expires, we cannot, madam, extend it. Let me find my affidavit, madam. Otherwise, we'll have to go for a fresh tender again to facilitate it. Let me find my affidavit, madam. I will pay the meeting. Short date, madam, will file affidavit.
But you don't take action. The interim order will be extended.
Yes, that part, yes.
Okay, then you will issue notice.
No. Yes.
Short notice will make it returnable.
Admission,
Okay.
yes. There are number.
Heard 3 BJ Ghosh Learned Counsel for the petitioner. Also heard 3 B. Gogol Learned Standing Counsel PWD. Full stop. This matter was taken up for consideration on 9/1/2026
1 to 5.
when the Learned Standing Counsel was directed to obtain instructions. Full stop. The Learned Standing Counsel has, however, submitted that some more time would be necessary so that the instructions can be put on record by way of an affidavit. That the matter pertains to notice a work which is sought to be done by the Public Works Department for construction of model secondary school in tea gardens, tea garden areas of Assam. Full stop. It also appears that there are pending litigations, including one before the Honorable Division Bench,
WA
being WA
365 of
365 of 2025. Full stop. Para. Let notice be issued. Returnable on, please give the
11, my lord, 11 to
11, okay, 11 to 2026. Sri Gogoi.
all.
The
One to five.
learned standing counsel accepts notice on behalf of all the respondents. Extra copies be served upon him by tomorrow. Sri, by tomorrow, Sri Ghosh, the learned counsel, has prayed for extension of the interim order which was passed on 9/1/2026, para, considering the facts and circumstances, comma, till the returnable date, the interim order passed earlier stands extended.
Because that WA, my lord, has been fixed before that division bench on 16/2. That is for my, your lordship, information. It's my duty to.
Yes, when do you want? Then tell me. Tell us.
I leave it to you. Can
No,
you?
you tell us.
My lord,
No, by 11, my lord, let us complete the pleadings, my lord. Maybe.
Then we can extend the date, 11th, after the pleadings.
Yes, yes.
and we may be filing.
Yes.
11, but this is a fresh cause of action.
Like, are you going to? '58, madam, you had mentioned this, why? Oh, KDB. It is for orders, isn't it? Why is it for order?
Let's say notice was issued last occasion.
As per court's order, the notice issued, obtained by speed post and Dusty. No affidavit is received, Dusty. You have not taken steps for when?
Because we have also received extra copy on 7/1.
But if you have taken steps on 9/1, no, that affidavit is another part. Taking steps for speed post, if you have taken on 9/1, this office note is of 21. You have a document to show. Please hand it over. Peruse the office note dated 20 bis Act 2026, as per which steps by this speed post with AD as well as justice service upon the response number 4 have not been taken. Para. Miss, your name, madam? Miss N.O. Pomong, learned counsel, has however informed that steps were indeed taken on 9/1/2026. Full stop. She has, however, submitted that the affidavit pertaining to the Dusty has not been filed, for which she prays for some time. Para. Raised it to verify and make a report, full stop, by the next date fixed. The affidavit in support of the Dusty service is also required to be filed. List on when? 30 January. Can you file before 30th? Okay, on 30 January. It will copy. You can take this back.